First, I'd like to thank my Lord the Chief Justice for giving me the opportunity to write for the bench. First, delineated the scope of the reference from the reference in the following terms. The scope of the reference is therefore limited to A, whether K. Manjushree lays down the correct law, and B, whether the rules of the game, qua method, and manner of making selection can be changed or altered after commencement of the recruitment process. We discussed the above issues in following segments. One, when the recruitment process commences and comes to an end, the basis of the doctrine that rules of the game must not be changed during the course of the game or after the game is played. Then whether the decision in K. Manjushree is at variance with earlier precedents on the subject, whether the above doctrine applies with equal strictness qua method or procedure for selection as it does qua eligibility criteria, whether procedure for selection stipulated by Act or rules framed either under the proviso to Article 309 of the Constitution or a statute could be given a go by, and whether appointment could be denied by change in the eligibility criteria after the game is played. As far as the basis of the doctrine is concerned, we relied on our earlier judgment in Sivanand CT. So far as the correctness of Manjushree is concerned, we examined the facts of that case as also the case of Subhash Chandra Marwa, and we held free. On the other hand, in K. Manjushree, the eligibility criteria for placement in the select list was challenged after interviews were held which had a material bearing on the select list. Thus, Subhash Chandra Marwa dealt with the right to be appointed from the select list, whereas K. Manjushree dealt with the right to be placed in the select list. The two cases, therefore, deal with altogether different issues. For the foregoing reasons, in our view, K. Manjushree could not have been doubted for having failed to consider K. Subhash Chandra Marwa. You told it. Yeah, doctor. Yeah. Thus, further, what is clear from the above is that the object of any process of selection for entry into public service is to ensure that a person most suitable for the post is selected. What is suitable for one post may not be for the other. Thus, a degree of discretion is necessary to be left to the employer to devise its method to select a candidate most suitable for the post, albeit subject to the overarching principles enshrined in Articles 14 and 16 of the Constitution, as also the rules/statute governing service and reservation. Thus, in our view, the appointing authority/recruiting authority/competent authority, in absence of rules to the contrary, can devise a procedure for selection of a candidate suitable to the post, and while doing so, it may also set benchmarks for different stages of the recruitment process, including written examination and interview. However, if any such benchmark is set, the same should be stipulated before the commencement of the recruitment process. But if the extant rules or the advertisement inviting applications empower the competent authority to set benchmarks at different stages of the recruitment process, then such benchmarks may be set any time before that stage is reached, so that neither the candidate nor the evaluator/examiner/interview is taken by surprise. The decision in K. Manjushree does not prescribe setting of benchmarks for various stages of the recruitment process, but mandates that it should not be set after the stage is over. In other words, after the game has already been played. This view is in consonance with the rule against arbitrariness enshrined in Article 14 of the Constitution and meets the legitimate expectation of the candidates, as also the requirement of transparency in recruitment to public services, and thereby obviates malpractices in preparation of select list. Then we examined whether it applies with equal strictness to steps for selection, and we cited few instances such as shortlisting and other evaluation instances. And then we considered whether the rule can be given a go by. And in this, we relied upon the judgment in Sivanandan CT, as also which was followed by a 3-judge bench in Salam Samarjit Singh. And finally, we considered whether appointment may be denied even after placement in the select list, where we relied on Shankarasan Das. So the final conclusions are as follows. The recruitment process commences from the issuance of the advertisement calling for applications and ends with filling up of vacancies. Eligibility criteria for being placed in the select list notified at the commencement of the recruitment process cannot be changed midway through the recruitment process unless the extent rules so permit or the advertisement which is not contrary to the extent rules so permit. If such change is permissible under the extent rules or the advertisement, the change would have to meet the requirement of Article 14 of the Constitution and satisfy the test of non-arbitrariness. The decision in K. Manjushree lays down good law and is not in conflict with the decision in Subhash Chandra Marwa. Subhash Chandra Marwa deals with the right to be appointed from the select list, whereas K. Manjushree deals with the right to be placed in the select list. The two cases therefore deal with altogether different issues. Recruiting bodies subject to the extent rules may devise appropriate procedure for bringing the recruitment process to its logical end, provided the procedure so adopted is transparent, non-discriminatory, non-arbitrary, and has a rational nexus to the object sought to be achieved. Extent rules having statutory force are binding on the recruiting body, both in terms of procedure and eligibility. However, where the rules are non-existent or silent, administrative instructions may fill in the gaps. Placement in the select list gives no indefeasible right to appointment. The state or its instrumentality for bona fide reasons may choose not to fill up the vacancies. However, if vacancies exist, the state or its instrumentality cannot arbitrarily deny appointment to a person within the zone of consideration in the select list. Let the appeals be placed before the appropriate bench for decision in terms of the answers rendered above, after obtaining administrative directions from Honorable Chief Justice.
Okay. So just looking at the
Thank you very much for all your assistance. See, the pivotal issue which fell for our consideration having regard to your submissions is whether the explanations appended to Rule 38 of the MCR 2016 and Rule 45 of the MCDR 2017 respectively are unreasonable and manifestly arbitrary, and in consequence of violation of Article 14 of the Constitution. So this is the question we have addressed. We have said, while examining the challenge to the validity of laws relating to economic activities, the courts must be slow and circumspect. A higher degree of deference needs to be shown in such matters, and sufficient flexibility should be given to the legislature and the executive in dealing with economic matters. Complex issues of economic and fiscal nature cannot be construed by any straitjacket formula or unidirectional approach. This court has time and again recognized that a judicial hands-off approach must be followed qua economic legislation, and that the legislature is to be allowed wide latitude in experimenting with economic legislation by virtue of it being an extension of the government's economic policy. Since the MMDR Act and the rules thereunder pertain to the extraction, disposal, and sale of natural resources, which is an economic policy that entails intricate economic choices and have a direct effect on the macroeconomics, we are of the considered opinion that when it comes to computation of royalty, the legislature must have greater play in the joints. The exclusion of royalty and contributions towards BMF and NMET paid previously for coal, but not for other minerals, may not be termed as arbitrary or unreasonable merely because the computation for one differs from the other in certain aspects. Deference needs to be shown to the legislature in deciding how royalty must be computed in respect of different mineral grades/concentrates. However, the present petition, more particularly the challenge to the validity of the explanations to Rule 38 of the MCR 2016 and Rule 45 of the MCDR 2017, is unique in its own way. While there is nothing to show that such policy is in excess of the powers or domain of the respondents herein, or in breach of any statutory provision, at the same time, we should not ignore or overlook the fact that the legislature itself has acknowledged the anomaly in compounding of royalty, etc., for the purpose of computation of average sale price. Similarly, although the discretion to exclude previously paid royalty and contributions for coal, but not for other minerals, cannot be approached in a rigid manner, yet it would be incorrect to import policies framed and tailored by the executive for one particular subject area and blanketly apply it to other related subject areas. It is the executive which is best suited to determine the fine distinctions existing between interlacing or seemingly similar domains and formulate distinct policies to best factor in the dissimilarities. Even in the respondents herein appear to have acknowledged that the differing mechanism for computation of royalty for coal and other minerals is not based on any fine distinction between the two, but rather an anomaly in the MCR 2016 and MCDR 17, which is why it constituted a committee to look into the same and has proposed amendments for rectifying the same. In view of the fact that the appropriate authorities are actively considering the issue of compounding royalties in the computation of average sale price for all other minerals, and the fact that the notice for public consultation on amending the MMDR Act to inter alia address the aforementioned issue, we may not say anything further as regards whether the explanations to Rule 38 of the MCR 16 and Rule 45 of the MCDR 2017 are manifestly arbitrary or not. Although the computation of royalty for different minerals is purely a matter of policy, yet we should not shut our eyes to the prima facie anomaly that exists both in the very computation mechanism of average sale price for minerals in terms of the aforesaid provisions and the perplexing stance of exclusion of only coal from such mechanism despite the general nature and application of the aforesaid rules. We intend to grant one last opportunity to the respondents herein to seriously consider the mechanism of computation of average sale for the purposes of determining the rate of royalty for all other minerals in terms of the explanations to Rule 38 of the MCR 16 and Rule 45 of the MCDR 2017. We direct the respondents to conclude the process of public consultation in respect of the compounding of royalties and take a well-meaning decision keeping in mind the representations made by the petitioners herein. We may remind the respondents that it cannot continue to keep the aforesaid issue in limbo on the pretext of ongoing process of public consultation process. Yes. So we have granted, just a minute. In view of the aforesaid, this is the note which we had prepared, Suvira, now the main judgment. In view of the aforesaid, we grant the respondents a period of 2 months from the date of pronouncement of this judgment to conclude the public consultation process undertaken for amending the MMDR Act initiated pursuant to the notice dated 25th of May 2022. I feel call in regard to the cascading impact of royalty on royalty in the calculation of the average sale price by virtue of the explanations to Rule 38 of the MCR 2000.
Hear the judgment till the end. There was a pause and there was a however. Teaches us that, however. Tell you what to do after this.
Assistance. Thank you very much.
Deeply obliged.
Thank you to all my law clerks also, relentlessly work.
Of course, above all, but it's very.
Who appeared in this matter?
Yes, I am.
You appear. Having heard the learned counsel appearing for the parties and having gone through the materials on record, the short question that falls for our consideration is whether we should decline to make a reference under Section 11(6) of the claims of the petitioner are ex facie and hopelessly time-bound. The conclusion is the existence of the arbitration agreement as contained in clause 13.10 of the shareholders' agreement is not disputed by either of the parties. The submissions as regard the claim of the petitioner being ex facie time-barred may be adjudicated upon by the arbitral tribunal as a preliminary issue. In view of the aforesaid, the present petition is allowed taking into consideration the fact that an arbitral tribunal comprising of a sole arbitrator, Mr. Mayur Khandeparkar, Advocate High Court of Judicature at Bombay, has already been constituted for the adjudication of disputes between the same parties in relation to the service agreement dated 18th of October 2011. It would be desirable to constitute an arbitral tribunal comprising of the same sole arbitrator for adjudication of the present disputes pertaining to the shareholders' agreement dated 25th of July 2011. The fees of the arbitrator, including other modalities, shall be fixed in consultation with the parties. This is how we have allowed it.
There's only one development. What has happened is the learned arbitrator has returned back the matter. It's saying that he has appeared for one of the parties. So I'll file a suitable application, Manoj, or
Mr. Mayur Khandeparkar doesn't want to.
yes, just a few weeks back, he's returned it. He's saying that he has appeared because they had taken an objection. So I'll have to file in both the matters, even in that matter, Manoj.
Ask a separate order. We can then, you are appealing for the other side, right?
Yes.
If Mr. Mayur Khandeparkar has said no, we can appoint somebody else actually.
Vishal Kanade was one of my names, Manoj, but subject to your lordship's pleasure, Manoj. Or any other name.
Yes. After the judgment is pronounced, the learned counsel appearing for the petitioner brought to our notice that Mr. Mayur Khandeparkar has shown his disinclination to act as the arbitral tribunal.
You have a letter, he's
He
communicating.
has in fact passed an order. He has
All right.
started the proceedings.
All right.
Then they informed him that
All
this
right.
appeared for them. That's why.
In such circumstances, we appoint Mr.
Vishal Kanade.
Vishal Kanade, I was suggesting.
Vishal Kanade, Advocate,
So Bombay High Court.
High Court of Bombay, as the arbitrator, sole arbitrator. Right?
Doing it only in this matter or that matter, I'll have to file an.
That matter you'll have to take out
Yes,
an application.
I'll take.
This because we are
I'm sorry,
seeing
Your
the
Lordship.
petition pass.
I understand. I was to do that, Manoj, but then
Your Lordship, I'm really sorry, but would it not be appropriate if they move an application so I can seek instructions on the suggested name?
That's all right. I mean,
Because they were to move an application, that's not happened.
We've appointed the same arbitrator. It's, I think, fair enough.
1504.
oblige, Manoj. Highly.
You appeared for the petitioner. Having heard the learned counsel appearing for the parties and having gone through the materials on record, the following questions of law fall for our consideration. 1. Whether the present petition under Section 11 of the Act 1996 is maintainable. 2. Whether Part 1 of the Act 1996 is applicable to the arbitration clause contained in the distributorship agreement dated 9th of November 2010. 3. What is the seat of the arbitration in terms of the distributorship agreement dated 9/11/2010? So these are the three questions which we have addressed. This is that UAE matter, exclusive jurisdiction of courts in Dubai. Our conclusion is, from the above exposition of law, the following position of law emerges. Part 1 of the Act 1996 and the provisions thereunder only applies where the arbitration takes place in India, that is, where either 1, the seat of arbitration is in India, or 2, the law governing the arbitration agreements are the laws of India. 2. Arbitration agreements executed after 6 September 2012, where the seat of arbitration is outside India, Part 1 of the Act 1996 and the provisions thereunder will not be applicable and would fall beyond the jurisdiction of Indian courts. 3. Even those arbitration agreements that have been executed prior to 6 September 2012 Part 1 of the Act 1996 will not be applicable if its application has been excluded by the parties in the arbitration agreement, either explicitly by designating the seat of arbitration outside India or implicitly by choosing the law governing the agreement to be any other law other than Indian law. 4. The moment sit is determined, it would be akin to an exclusive jurisdiction clause whereby only the jurisdictional courts of that seat alone will have the jurisdiction to regulate the arbitral proceedings. The notional doctrine of concurrent jurisdiction has been expressly rejected and overruled by this court in its subsequent decisions. 5. The closest connection test for determining the seat of arbitration by identifying the law with which the agreement to arbitrate has its closest and most real connection is no longer a viable criteria for determination of the seat or situs of arbitration in view of the Sashao principle. The seat of arbitration cannot be determined by formulaic and unpredictable application of choice of law rules based on abstract connecting factors to the underlying contract. Even if the law governing the contract has been expressly stipulated, it does not mean that the law governing the arbitration agreement and by extension, the seat of arbitration will be the same as the lex contractus. 6. The more appropriate criterion for determining the seat of arbitration in view of the subsequent decisions of this court is that where in an arbitration agreement there is an express designation of a place of arbitration anchoring the arbitral proceedings to such place, and there being no other significant contrary indicia to show otherwise, such place would be the seat of arbitration, even if it is designated in the nomenclature of venue in the arbitration agreement. 7. Where the curial law of a particular place or supranational body of rules has been stipulated in an arbitration agreement or clause, such stipulation is a positive indicium that the place so designated is actually the seat, as more often than not the law governing the arbitration agreement, and by extension the seat of the arbitration tends to coincide with the curial law. 8. Merely because the parties have stipulated a venue without any express choice of a seat, the courts cannot sideline the specific choices made by the parties in the arbitration agreement by imputing these stipulations as inadvertence at the behest of the parties as regards the seat of arbitration. Deference has to be shown to each and every choice and stipulations made by the parties. After all, the courts are only a conduit or means to arbitration, and the sum and substance of the arbitration is derived from the choices of the parties and their intentions contained in the arbitration agreement. It is the duty of the court to give weight and due consideration to each choice made by the parties and to construe the arbitration agreement in a manner that aligns the most with such stipulations and intentions. 9. We do not for a moment say that the closest connection test has no application whatsoever, where there is no express or implied designation of a place of arbitration in the agreement, either in the form of venue or curial law. There, the closest connection test may be more suitable for determining the seat of arbitration. 10. Where two or more possible places that have been designated in the arbitration agreement, either expressly or impliedly, equally appear to be the seat of arbitration, then in such cases, the conflict may be resolved through recourse to the doctrine of forum non-convenience, and the seat be then determined based on which one of the possible places may be the most appropriate forum, keeping in mind the nature of the agreement, the dispute at hand, the parties themselves and their intentions. The place most suited for the interests of all the parties and the ends of justice may be determined as the seat of arbitration. Thus, for all the foregoing reasons, we have reached a conclusion that the present petition under Section 11 of the Act 1996 is not maintainable, as neither the seat of arbitration is in India, nor is the arbitration agreement governed by laws of India. In the result, the present petition filed by the petitioner fails and is hereby dismissed. You appeared for HPCL?
Yes,
Yes, Professor.
The argument of the other side, the petitioner, was that the application under Section 11 filed before the Bombay High Court was not maintainable because it was a fresh application filed. Your client, having filed, unconditionally withdrawn, takes recourse to the IBC proceedings, pays up to this court in the IBC. You went again to the High Court, filed a fresh application. Therefore, in this background, we have addressed ourselves to three questions. One, whether a fresh application under Section 11, subsection 6 of the Act 1996 filed by the respondent could be said to be maintainable, more particularly when no liberty to file a fresh application was granted by the High Court at the time of withdrawal of the first application under Section 11(6) of the Act 1996. Two, whether the fresh application under Section 11(6) of the Act 1996 filed by the respondent on 9th December 2022 could be said to be time-bound. If yes, whether the respondent is entitled to the benefit of Section 14 of the Limitation Act. In other words, whether the period spent by the respondent in pursuing proceedings under the IBC is liable to be excluded while computing the limitation period for filing the application under Section 11(6). And three, whether the delay caused by the respondent in filing the fresh arbitration application under Section 11(6) of 1996 can be condoned under Section 5 of the Limitation Act. Our judgment proceeds on the footing that your fresh application was not maintainable, applying the provisions of Order 23 of the CPC. We have gone ahead in saying, assuming for the moment that it was maintainable, it was time barred, and 14(2) would not save the period of limitation because it cannot be said to be for the same relief. IBC proceedings differ from the arbitration proceedings. So all three issues we have decided accordingly. And our final conclusion is, in view of the aforesaid discussion, we have reached to the following conclusion. In the absence of any liberty being granted at the time of withdrawal of the first application under Section 11(6) of the Act 1996, the fresh application filed by the respondent under the same provision was not maintainable. Two, the fresh application filed by the respondent under Section 11, subsection 6 of the Act 1996 was time-barred. Three, the respondent is not entitled to the benefit of Section 14, subsection 2 of the Limitation Act, and the respondent is also not entitled to the benefit of condonation of delay under Section 5 of the Limitation Act. In such circumstances, we have set aside the judgment of the Bombay High Court. The appeal is allowed accordingly.
Gratefully.
This litigation is an eye-opener. As taught one and all many lessons. So far as IBC is concerned, the functioning of the NCLT, NCLAT, but we have given due consideration to all the submissions canvassed on either side. Mr. Venkatraman's submissions, Mr. Shankar Narayan and your submissions, Mr. Rohatgi's submissions. And we have considered the matter threadbare. Having regard to the issues that fell for our consideration, we have addressed ourselves to three questions. One, whether the performance bank guarantee could have been adjusted against the first tranche payment, which was to be made under the resolution plan within 180 days from the effective date, in contravention of the order of this court dated 18 January 2024, the terms of the resolution plan and the provisions of law. To put it in other words, whether the impugned order of the NCLAT allowing the adjustment of the performance bank guarantee in lieu of payment of the first tranche could be said to be perverse. Two, whether the non-implementation of the resolution plan by the SRA necessarily leads to the consequence of liquidation as provided under Section 33, subsection 3 of the IBC 2016. And three, whether the timely implementation of the resolution plan is also one of the objectives of the IBC 2016. A preliminary objection was raised on behalf of the SRA that the scope of an appeal under Section 62 of the IBC 2016 is restricted to a question of law. In our considered view, the impugned order of the NCLAT directing the SRA to adjust the PBG of rupees 150 crore against the first tranche payment of rupees 350 crore was in flagrant disregard of the order of this court dated 18th of January 2023, the terms of the resolution plan and the established law. Such an order was perverse for not having properly considered several material and relevant facts and misreading the evidence on record. Furthermore, the non-infusion and non-payment of funds in compliance with the applicable laws and the terms of the resolution plan led to circumstances causing a failure of the resolution. We have no doubt in our mind that the NCLAT acted contrary to the settled legal principles and went to the extent of drawing wrong inferences from proved facts while deciding the matter. This itself justifies the examination of various issues in exercise of our jurisdiction afforded to us under Section 62 of the IBC 2016. Therefore, we have overruled the preliminary objection that there is no substantial question of law involved in this appeal. On the first issue, we have come to the conclusion that the performance bank guarantee of rupees 150 crore could not have been adjusted against the first tranche payment of rupees 350 crore, which was to be made by the SRA under the resolution plan, since the same is in flagrant violation of our order dated 18 January 2024, the terms of the resolution plan and the provisions of law. The adjustment of the PBG could not have been allowed since it was in direct breach of the terms of the request for resolution plan, specifically clause 3.13.2, 3.13.8, and 3.13.9 respectively, which was made binding on the SRA through clauses 7.3 and 9.4 respectively of the resolution plan. The RFRP is clear in its intention that the PBG shall not be set off or used as a part of the consideration that was to be given by the SRA under the plan. 5. Allowing such an adjustment was also in direct violation of Regulation 36 capital B 4 capital A of the IBBI, Insolvency Resolution Process for Corporate Persons, Regulations 2016. According to the Regulation 36B 4 capital A, the PBG furnished by the SRA would be liable to be forfeited if the SRA fails to implement or contributes to the failure of implementation of the resolution plan. Therefore, the PBG had to be kept alive until the completion of the implementation of the resolution plan. 6. The contention of the SRA that the adjustment of the PBG towards the first tranche payment was only impossible under the terms of the lender's affidavit dated 16th of August 2023 and was permissible under the terms of the resolution plan must be rejected. This is because once the resolution plan had been approved by the adjudicating authority under section 31, subsection 1 of the IBC, it was made binding on all the stakeholders and was immune to any modification. Therefore, the lender's affidavit could not have imposed conditions which were different from those provided under the resolution plan. This is the context in which our order dated 18 January 2024 directing an infusion of rupees 150 crore in cash was made. Such an infusion in cash was required under both the lender's affidavit and the terms of the resolution plan as well. The NCLAT incorrectly interpreted our order and held that our observations were restricted to the conditions under the lender's affidavit only. Therefore, the impugned order incorrectly allowed the adjustment of the PBG of rupees 150 crore against the first tranche payment by directly violating the direction of this court, the terms of the resolution plan, and the provisions of law. On the second issue, we have arrived at the finding that the SRA failed to implement the resolution plan by not infusing the first tranche payment of rupees 350 crore in cash as required by clause 6.3.1 bracket small g and the implementation schedule under clause 7.7 of the resolution plan. The SRA, by not infusing the first tranche payment as per the terms of the resolution plan, had also defaulted on its obligation towards the payment of CIRP costs, which include airport dues under clause 6.4.1 of the resolution plan. 9. The SRA, not having infused the first tranche payment as per the terms of the resolution plan, could also be said to have breached clause 6.4.2 of the resolution plan, which required a minimum liquidation value to be paid towards the workmen and employees as well. Moreover, both the Provident Fund and gratuity dues amounting rupees 226 crore should also have been paid by the SRA in accordance with the order dated 21st of October 2022 of the NCLAT in fulfillment of its obligations, which it failed to do. 10. Therefore, there were sufficient grounds before the NCLAT and there are sufficient grounds now before us to hold that the SRA has contravened the terms of the resolution plan and the corporate debtor must therefore be directed to be taken in liquidation as per section 33 subsection 3 of the IBC 2016. On account of the inordinate delay in the implementation of the resolution plan, several dues, including the CIRP costs of the corporate debtor, have continuously multiplied. The appellants are incurring huge expenditure and costs each month towards maintenance of the corporate debtor. The fundamental concern of this court must not only be of doing substantial and complete justice, but also to ensure expeditious resolution of the issues in the interests of the underlying objective of the IBC and all the stakeholders involved. We must obviate the possibility of the corporate debtor being stuck, embroiled, and its resolution being further delayed, especially in light of the delay that has already ensued. Having due regard to the materials on record, a determination that the terms of the resolution plan have been contravened and that there has been a failure to implement on part of the SRA has already been made on a consideration of the issues before us. As such, since the resolution plan is no longer capable of being implemented, we must ensure that at least liquidation remains as a viable last resort for the corporate debtor and its creditors. Being mindful of the underlying objective that time and speed are of the essence under the code, and to prevent the frustration of this objective, we have thought fit and necessary to exercise our plenary powers under Article 142 and direct a corporate debtor into liquidation in the manner as laid in the IBC. Granting this relief to the appellants would not run counter to the timelines and predictability that is central to IBC. On the contrary, it would be in furtherance of it. Ensuring that liquidation commences as soon as possible would also be in the best interest of the corporate debtor and the creditors, including the workmen, employees who are yet to receive their rightful dues. This litigation has also given us an opportunity to suggest few things, which of course it is for the Parliament to look into, but the suggestions are important on varied aspects of the matter. Our final conclusion is like this. As a result, the appeals succeed and are allowed. The impugned order passed by the NCLT is set aside. In the peculiar and alarming circumstances as discussed in this judgment, and also keeping in mind the fact that almost 5 years have elapsed since the resolution plan was duly approved by the NCLT, and there being no progress worth the name, we are left with no other option but to invoke our jurisdiction under Article 142 of the Constitution and direct that the corporate debtor be taken in liquidation. The NCLT Mumbai shall now take appropriate steps for appointment of liquidator and all other necessary formalities for commencement of liquidation of the corporate debtor. The amount of rupees 200 crore already infused by the SRA stands forfeited. The lenders, creditors are further permitted to encash the performance bank guarantee of rupees 150 crore furnished by the SRA. We accordingly order so. These appeals are disposed of in the aforesaid terms.
May I just bring one incidental issue to your Lordship's notice? My Lord, there are a series of cases filed against the erstwhile resolution professional. My Lord, we had taken out one application praying, my Lord, that because of this delay, my Lord, we are now hounded in several fora across the country. Lord, my application was praying for some immunity, my Lord, to the resolution professional, because many cases, my Lord, the RP ends up being the liquidator also. Lord, my application is 230101.
We'll have to look into independently.
That can be listed.
Listed afterwards. For the present, this is our.
Lordship,
So, Mr. Venkatraman, thank you very much for your valuable assistance. Mr. Shankar Narayan, thank you very much.
Grateful.
Thankful to my law clerks also, assisted me
Big learning curve.
brilliantly. Thank you very much.
May I pray for early listing of my application at your Lordship's convenience? 230101.
You can just mention the
Well,
list.
I'll do that. I'm grateful.
This is a short matter. Who appeared? We have appointed Mr. Shavak Wazifdar, former Chief Justice of the Punjab and Haryana High Court, as the sole arbitrator to adjudicate the dispute between the parties.
Grateful, Lordships.
My learned brother thanked all of you. I must thank him because, if I let out a secret, that I don't think he has slept for the last 3 or 4 nights. He's been constantly working around the clock, to get all the judgments ready because.
With my entire team.
How fortunate they are to have learned so much. God bless you all.
This is a nostalgic moment for me, Mr. Venkatraman. This is the last judgment I am pronouncing with my Lord, the Chief Justice, authored by me. Otherwise, we have few judgments
Which will be pronounced
tomorrow. But these are all judgments which I had the honor and privilege to author with the able guidance of my Lord, the Chief Justice, and my learned brother, Justice Manoj MISRA. So that is why I'm a little nostalgic about this. And this is your matter, right? Having heard the learned counsel appearing for the parties and having gone through the materials on record, following questions call for our consideration. 1. Whether there is an error apparent on the face of the record for the purpose of entertaining the review petition. 2. If the answer to the aforesaid question is in the affirmative, then whether the exposition of law propounded by this court in Canon India as regards the power of the DRI to issue show cause notices would be said to be the correct statement of law. This would entail addressal of the following questions. A. Whether officers of DRI are the proper officers for the purposes of Section 28 of the Act 1962. B. What would be the extent, scope, and domain of Section 6 of the Act 1962 vis-a-vis Section 2, subsection 34, Section 3, Section 4, and Section 5 of the Act 1962, and whether an entrustment by the central government under Section 6 of the Act 1962 is mandatory to empower the officers of the DRI for the purpose of issuing show cause notices. C. Whether the power under Section 28 can be exercised only by someone who is empowered to exercise the power under Section 17 of the Act 1962 for the goods in question. In other words, how best the meaning of the expression proper officer should be construed for the purposes of exercise of functions under Section 28. D. Whether the proper officer in Section 28 must necessarily be the same proper officer referred to under Section 17 of the Act 1962. If no, whether the use of the definite article "the" in the expression "the proper officer" in Section 28 is in the context of that proper officer who has been assigned the powers of discharging the functions under Section 28 by virtue of powers conferred under Section 5 of the Act 1962. E. Whether issuance of show cause notices followed by adjudication under Section 28 of the Act 1962 is an administrative review as held in Canon India or a quasi-judicial exercise of power under administrative law. Whether the introduction of Section 28, subsection 11, within the Validation Act of 2011, which retrospectively validates the show cause notices issued under Section 28 with effect from 6/7/2011 is discriminatory and arbitrary for not curing the defect highlighted in Syed Ali, and therefore is violative of Article 14 of the Constitution of India. Whether the judgment delivered by the High Court of Delhi in the case of Mangli impacts expounds the correct interpretation of Section 28, subsection 11, and whether Section 97 of the Finance Act 2022, which retrospectively validates the show cause notices with effect from 1/4/2023, is manifestly arbitrary and therefore violative of Article 14 of the Constitution of India. These are the issues which we have highlighted. Section 17, read with sections 46 and 47 of the Act 1962 respectively, deals with the assessment and reassessment at the first instance, that is, upon entry of the consignments and clearance of bills of entry. The amendment to Section 17 introduces the process of self-assessment and subsequent reassessment upon verification by the proper officer, if so required, for undertaking a check at the first instance. The proceedings under Section 28 are subsequent to the completion of the process set out in Section 17 of the Act 1962. The procedure envisaged under Section 28 is in the nature of a quasi-judicial proceeding with the issuance of the show cause notice by the proper officer, followed by adjudication of such notices by the field customs officers. It is also worth noting that in the case of DRI, the proceedings under Section 28 start only after an investigation has been undertaken by DRI. This is reaffirmed by Circular number 4 of 1999, dated 15th of February 1999, and Circular number 44 of 2011, dated 23rd of November 2011. Therefore, the nature of review under Section 28 is significantly different from the nature of assessment and reassessment under Section 17. The ambit of Section 28 has also been restricted to the review of assessments and reassessments done under Section 17 for ascertaining if there has been a short levy, non-levy, part payment, non-payment, or erroneous refund. Keeping this statutory scheme in mind, we are unable to subscribe to the view taken in both Syed Ali and Canon India that the vesting of the functions of assessment and reassessment under Section 17 is a threshold mandatory condition for a proper officer to perform functions under Section 28. In fact, this is an error apparent on the face of the record. This scheme does not flow from the scheme of the statute and was judicially read in to avoid the possibility of chaos and confusion due to the potential for multiple proper officers exercising jurisdiction under Section 28. We find that such apprehensions of misuse are unfounded, considering that no substantial empirical evidence has been brought forth by the respondents in this case to support such a view. Regardless, the parameters under Section 28 cannot be reduced to an administrative review of assessment, reassessment done under Section 17. We are conscious of the fact that Section 110AA of the Act 1962, which has been introduced by the Finance Act 2022, stipulates that the show cause notice under Section 28 of the Act can only be issued by that proper officer who has been conferred with the jurisdiction by an assignment of functions under Section 5 of the Act 1962 to conduct assessment under Section 17 of the Act in respect of such duty. However, we are of the view that the introduction of Section 110AA doesn't alter the statutory scheme of Section 17 and 28 of the Act 1962 as it stood prior to the introduction of Section 110AA. The legislature, in its wisdom, may introduce certain new provisions, keeping in mind the exigencies of administration and taking into account the evolution of law. However, this would not by itself mean that the procedure which was being followed prior to the introduction of such changes was incorrect or in contravention of the law. The legality and correctness of an action has to be judged based on the statutory scheme prevailing at the time when such action took place, and incorrectness or invalidity cannot be imputed to it on the basis of subsequent changes in law. Seen thus, the contention of the respondents that Section 110AA of the Act amounts to an admission by the petitioner on the invalidity of the legal position existing prior to its introduction deserves to be rejected. Therefore, in our considered view, the scheme of Section 17 and 28 of the Act 1962 respectively indicates that there cannot be a mandatory condition linking the two provisions, and the interpretation of this code in the cases of Syed Ali and Canon is patently erroneous. This court in Canon India, while laying much emphasis on the use of the expression, I quote, the proper officer, unquote, observed that the Parliament had employed the article the instead of a/n in Section 28 of the Act 1962, so as to give effect to its intention of specifying that the proper officer referred to in Section 28 is the same officer as the one referred to in Section 17. The court further observed that the use of a definite article instead of an indefinite article is indicative of the fact that the proper officer referred to in Section 28 is not any proper officer, but the proper officer assigned with the function of assessment and reassessment under Section 17. However, there is an error apparent in the aforesaid view. Undoubtedly, a definite article the has been used before proper officer with a view to limit the exercise of powers under Section 28 by a specific proper officer and not any proper officer. But in the absence of any statutory linkage between Section 17 and 28 of the Act, respectively, there was no legal footing for this court in Canon, India to hold that the proper officer in Section 28 must necessarily be the same proper officer referred to under Section 17 of the Act 1962. As we have discussed in the foregoing parts of this judgment, the statutory scheme of the Act 1962 necessitates that a proper officer can only perform specific functions under the Act if he has been assigned as the proper officer to perform such functions by an appropriate notification issued by the competent authority. Seen thus, it becomes clear that an officer of customs can only perform the functions under Section 28 of the Act 1962 if such officer has been designated as the proper officer for the purposes of Section 28 by an appropriate notification. The use of the article "the" in the expression "the proper officer" should be read in the context of that proper officer who has been conferred with the powers of discharging the functions of Section 28 by conferment under Section 5. In other words, the proper officer is qua the function or power to be discharged or exercised. Thus, the definite article "the" in Section 28 refers to a proper officer who has been conferred with the powers to discharge functions under Section 28 by virtue of a notification issued by the competent authority under Section 5. In other words, the use of article "the" in Section 28 has no apparent relation with the proper officer referred to under Section 70. The proper officer under Section 28 could be said to be determinable only in the sense that he is a proper officer who has been empowered to perform the functions under Section 28 by means of a notification issued under Section 5 of the Act. In Canon, India, this court held that DRI officers did not have the power of issuing show cause notices under Section 28 as they did not fall within the meaning of the expression "the proper officers" used in Section 28 for the reason that they did not possess the power of assessment under Section 17 of the Act 1962. However, as we have discussed earlier, contrary to the aforesaid observations of the court, DRI officers were notified as the proper officer for the purposes of Section 17 and 28 of the Act, respectively, with a notification number 44 of 2011, dated 6/7/2011, issued by the central government. Hence, those officers of DRI who were designated as the proper officer for the purpose of Section 28 by the aforesaid notification were competent to issue show cause notices under Section 28. Grace on statute law has stated that, I quote, "The language of statutes is not always that which a rigid grammarian would use. It must be borne in mind that a statute consists of two parts, the letter and the sense." Unquote. It was observed by this court in State of Andhra Pradesh versus Gnaneshwar Rao, reported in AIR 1963 Supreme Court 1850, that the aforesaid rule of construction, that the provisions of a statute are to be read together and given effect to, and that it is a duty of the court to construe a statute harmoniously, has gained general acceptance. In management, SSL Railway Company versus SSRW Union, reported in AIR 1969 Supreme Court 513, this court observed that the principle that literal meaning of the word in a statute is to be preferred is subject to the exception that if such literal sense would give rise to an anomaly or would result in something which would defeat the purpose of the Act, a strict grammatical adherence to the words should be avoided as far as possible. The above principles would help us to desist from affording undue stress on the definite article "the" used before the expression "proper officer" in Section 28 of the Act 1962. We have discussed few other aspects also, highlighting why Canon India fell in error. A final conclusion. In view of the aforesaid discussion, we conclude that 1. DRI officers came to be appointed as the officers of customs with a notification number 19 of 90, dated 26/4/1990, issued by the Department of Revenue, Ministry of Finance, Government of India. This notification later came to be superseded by notification number 17 of 2002, dated 7th of March 2002, issued by the Department of Revenue, Ministry of Finance, Government of India, to account for administrative changes. 2. The petition seeking review of the decision in Canon India is allowed for the following reasons. 1. Circular number 4 of 99, dated 15th of February 99, issued by the Central Board of Excise and Customs, New Delhi, which empowered the officers of DRI to issue show cause notices under Section 28 of the Act, as well as notification number 44 of 2011, dated 6th of July 2011, which assigned the functions of the proper officer for the purposes of Sections 17 and 28 of the Act, respectively, to the officers of DRI were not brought to the notice of this court during the proceedings in Canon India. In other words, the judgment in Canon India was rendered without looking into the circular and the notification referred to above, thereby seriously affecting the correctness of the same. 2. The decision in Canon India failed to consider the statutory scheme of Sections 2, subsection 34 and 5 of the Act 1962, respectively. As a result, the decision erroneously recorded the finding that since DRI officers were not entrusted with the functions of a proper officer for the purposes of Section 28, in accordance with Section 6, they did not possess the jurisdiction to issue show cause notices for the recovery of duty under Section 28 of the Act 1963. 3. The reliance placed in Canon India on the decision in Syed Ali is misplaced for 2 reasons. First, Syed Ali dealt with the case of officers of customs preventive who, on the date of the decision in Syed Ali, were not empowered to issue show cause notices under Section 28 of the Act 1962, unlike the officers of DRI. And secondly, the decision in Syed Ali took into consideration Section 17 of the Act 1962 as it stood prior to its amendment by the Finance Act 2011. However, the assessment orders in respect of which the show cause notices and the challenge in Canon India were issued were passed under Section 17 of the Act as amended by the Finance Act 2011. 3. This court in Canon India based its judgment on 2 grounds. 1. The show cause notices issued by the DRI officers were invalid for want of jurisdiction. And 2. Show cause notices were issued after the expiry of the prescribed limitation period. In the present judgment, we have only considered and reviewed the decision in Canon India to the extent that it pertains to the first ground, that is, the jurisdiction of the DRI officers to issue show cause notices under Section 28. We clarify that the observations made by this court in Canon India on the aspect of limitation have neither been considered nor reviewed by way of this decision. Thus, this decision will not disturb the findings of this court in Canon India insofar as the issue of limitation is concerned. 4. The Delhi High Court in Mangli Impacts observed that Section 28, subsection 11, could not be said to have cured the defect pointed out in Syed Ali, as the possibility of chaos and confusion would continue to subsist despite the introduction of the said section with retrospective effect. In view of this, the High Court declined to give retrospective operation to Section 28(11) for the period prior to 8 of April 2011 by harmoniously construing it with explanation 2 to Section 28 of the Act 1962. This was the main plank of your submission. We are of the considered view that the decision in Mangli Impacts failed to take into account the policy being followed by the Customs Department since 1999, which provides for the exclusion of jurisdiction of all other proper officers once a show cause notice by a particular proper officer is issued. It could be said that this policy provides a sufficient safeguard against the apprehension of the issuance of multiple show cause notices to the same SSC under Section 28 of the Act. Further, the High Court could not have applied the doctrine of harmonious construction to harmonize Section 28(11) with Explanation 2, because Section 28(11) and Explanation 2 operate in two distinct fields and no inherent contradiction can be said to exist between the two. Therefore, we set aside the decision in Mangling Pax and approve the view taken by the High Court of Bombay in the case of Sunil Gupta. Section 97 of the Finance Act 2022, which inter alia retrospectively validated all show cause notices under Section 28 of the Act, cannot be said to be unconstitutional. It cannot be said that Section 97 fails to cure the defect pointed out in Canon India, nor is it manifestly arbitrary, disproportionate, and overbroad. For the reasons recorded in the foregoing parts of this judgment, we clarify that the findings in respect of the vires of the Finance Act 2022 is confined only to the questions raised in the petition seeking review of the judgment in Canon India. The challenge to the Finance Act 2022 on grounds other than those dealt with herein, if any, are kept open. Subject to the observations made in this judgment, the officers of Directorate of Revenue Intelligence, Commissionerates of Customs Preventive, Directorate General of Central Excise Intelligence, and Commissionerates of Central Excise and other similarly situated officers are proper officers for the purposes of Section 28 and are competent to issue show cause notice thereunder. Therefore, any challenge made to the maintainability of such show cause notices issued by this particular class of officers on the ground of want of jurisdiction for not being the proper officer, which remain pending before various forums, including this court, shall now be dealt with in the following manner. A. Where the show cause notices issued under Section 28 of the Act 1962 have been challenged before the High Courts directly by way of a writ petition, the respective High Court shall dispose of such writ petitions in accordance with the observations made in this judgment and restore such notices for adjudication by the proper officer under Section 28. B. Where the writ petitions have been disposed of by the respective High Court and appeals have been preferred against such orders which are pending before this court, they shall be disposed of in accordance with this decision, and the show cause notices impugned therein shall be restored for adjudication by the proper officer under Section 28. C. Where the orders in original passed by the adjudicating authority under Section 28 have been challenged before the High Courts on the ground of maintainability due to lack of jurisdiction of the proper officer to issue show cause notices, the respective High Court shall grant 8 weeks' time to the respective SSC to prefer appropriate appeal before the Customs, Excise, and Service Tax Appellate Tribunal, that is the SISTAT. E. Where the writ petitions have been disposed of by the High Court and appeals have been preferred against them, which are pending before this court, they shall be disposed of in accordance with this decision, and this court shall grant 8 weeks' time to the respective SSC to prefer appropriate appeals before the SISTAT. E. Where the orders of SISTAT have been challenged before this court or the respective High Court on the ground of maintainability due to lack of jurisdiction of the proper officer to issue show cause notices, this court or the respective High Court shall dispose of such appeals or writ petitions in accordance with the ruling in this judgment and restore such notices to the SISTAT for hearing the matter on merits. Where appeals against the orders in original involving issues pertaining to the jurisdiction of the proper officer to issue show cause notices under Section 28 are pending before the SISTAT, they shall now be decided in accordance with the observations made in this decision. In view of the aforesaid, we allow the review petition number 400 of 2021, titled Commissioner of Customs versus Measures Canon India Limited, and the connected review petition numbers 401, 402, and 403 of 2021 respectively, insofar as the issue of jurisdiction of the proper officer to issue show cause notice under section 28 is concerned. As discussed, the findings of this court in Canon India in respect of the show cause notices having been issued beyond the limitation period remain undisturbed. We set aside the decision of the High Court of Delhi rendered in the case of Mangle Impacts and uphold the view taken by the High Court of Bombay in the case of Sunil Gupta. We also uphold the constitutional validity of Section 97 of the Finance Act 2022.
Extremely obliging.
May I request,
My lords.
may I request Mr. Lakshmi Kumaran to be unmuted? He has made a request to be unmuted. Yes.
My lord, extremely
Yes,
grateful.
Kumar.
Only thing, my lord, the matter, actually the Canon Nikon matters, which my lords have just now disposed of, the matters, these matters have to be remanded to the tribunal for their decision on merits, because some portion within the time limit, and therefore that has to be sent to them, because all the remand, this particular portion probably was missing. So I request my lord to remand those matters.
Mr. Venkatam,
To
the
the-
matters have to be sent back to the court masters that will be
Yes.
announced, that those are to be remanded back.
Just give one paragraph for this.
Extremely
lord's
grateful,
kindly-
extremely grateful.
Also, maybe also be permitted to join your nostalgic moments because this dispute started in 2006 and I had the privilege of appearing before His Lordship since 2007 for 17 long years.
We are
This can't be a better
grateful to Mr.
culmination.
Lakshmi Narayanan, Ms.
Saranya.
Charanya and her team, you, Mr. Venkatraman. But for your able assistance, it would be difficult to decide these complex issues.
So we have concluded TOLA and we have concluded canon, recruitment canon.
This dispute syntax.
With my lord's kind leave, minutes, item 102.
Yes.
I'm afraid, minutes, it has nothing to do with the present issue. When the notice was issued, it's been mentioned post
There's a
after the
disagreement.
decision in
There's a
review.
disagreement.
Covered by
Yeah,
that. Yes.
we have disagreement.
It's-
Correct.
Minutes, as far as 102, that may have to be detagged, minutes, that's to be heard because that's the
But they have
dispute concerns SEZ.
They rely on canon. But he's mentioned it last
No,
time.
minutes, it is, in fact, my lords indicated on the last occasion, await the outcome and then mention so that that could be
Later
taken a
on.
decision on. Minutes here, completely unconnected. And the issue is minutes 102 minutes. The issue is minutes whether SEZ Act applies or Customs Act applies, not with regard to
Obviously, they have
proper
relied
officer.
on canon. We showed it on the last
Minutes.
occasion. Last paragraph.
My lords may kindly come, if at all, minutes, para 35. Incidentally, the Honorable High Court has said that it's also been
We
covered.
have delivered judgment now. We have delivered our
Minutes, my lords may kindly say, minutes, notice was issued on 16/1. If I have a minute, minutes, on 16/1/2023, notice was given. That day it was said that await the outcome and then post after. And I'm afraid.
Please, Your Lordships.
Yes, Manoj, if I may mention.
Yes.
Yes, Manoj, I'm sorry, Manoj. Manoj, I want to mention this matter. I had mentioned it earlier. This was a matter, Manoj, that coal matter. Manoj, this was my coal matter, which comes with the coal batch of matters.
Yes.
On my mentioning, your Lordship had marked it to a coordinate bench, although there was a tagging order. When the matter came up before the coordinate bench, Manoj, the court requested me to re-mention the matter before this court. When the matter came up,
The matter was detagged at your place.
correct. Manoj, when the matter, let me finish. Manoj, when the matter was detagged, it was
Yes.
marked to another court. Manoj, that's what I'm saying.
Yes.
When the matter came up day before yesterday, Manoj,
Before that bench.
that bench, the
Yes.
bench requested me that because this issue is pending in a number of matters which is listed today before your court, Manoj, please see the order of the coordinate bench. They said please mention and request court number 1 if this matter could be taken with those other matters where the same issue is pending. That's why, Manoj, I'm mentioning it, or I would not have. Your Lordship, this happened in court.
I'll see what to do about it.
Yes.
Please.
Your Lordship, the order, Manoj, the coordinate.
One second. I say, observe some order. We go from left to right. You're not going to allow anybody to just jump up and mention like this. This is the first court. Yes.
Yes, Manoj.
And he's on his legs.
I'm only mentioning because the court directed me, Manoj, to make a request before court number 1, and an order has been passing.
All right, I'll just look at it. I'll look at the order and we'll take a call.
I'm very grateful.
Anybody else here?
My lord, I'm mentioning a
Hallelujah.
fresh SLP of bail, my lord. I have filed it is numbered. coordinate bench had dealt with the case of a co-accused.
चलो बंद करो
Yes.
ये लंच
So,
के
मतलब-
बाद देंगे.
All right, you send your email, I'll look at it. Yes,
Yesterday's matter, that family dispute about a restaurant, your lordship permitted us to come back after seeing the order, but both the councils have agreed on some.
on the modalities or on the,
Only on the modalities.
all right, just sure.
We have agreed on the valuator, my lords.
Signed by both the parties, both the councils.
We can do it. My lords, there are just a few,
So we've dictated the order now.
my lords.
So these small changes may have to be made. These are agreed by both sides. my lord.
All right, let's just see 1 second. We'll look at the order.
Yes.
Which part of the order,
My
Mr.
lord,
Reddy?
in para 10, my lord, this name has come. Anandam and Company Chartered Accountants have been agreed. This is my lord, my first suggestion goes. In para 9, my lords,
During the course of the hearing, just read the whole para. It has been agreed that in order to resolve the disputes between the parties finally, a valuer may be appointed so that the business of the partnership can be valued inclusive of all its assets, goodwill and liabilities.
yes. So Anandam and Company has come. That's agreed.
Once a net current valuation is arrived at, it has been agreed that the petitioner shall have the first right of refusal to take over the first respondent, to take over an account name, to take over
From the first,
to take over the share of the first respondent,
to take over the share of the first.
equivalent, an account will cut equivalent to a share of to take over the share of the first respondent. We'll say equivalent to our share will be of 14% in the partnership within a period of 2 weeks of the date of the valuation.
My lords, we request my lord to make it 4 weeks. We have agreed.
All right, to 4 weeks of the date of valuation. Then,
But in para 11,
yeah,
my lord, the expression that has come is, my lord,
Full
the sole asset belonging to the business of the partnership firm.
and the implementation, the first petitioner shall act as the receiver of the business and affairs of the partnership in the restaurant. Yes.
But in para 11, my lord, we are only praying, my lord, that this is the sole business of the partnership firm. Assets are many. There are restaurants and other properties.
Which is the sole business. All right.
Yes. So those words, assets belonging to the business, may have to go.
Which is the sole business
Of the partnership.
of the partnership.
Yes.
Right? No problem.
Yes. But in para 9,
Yes.
my lord, the expression that is used is, my lord, valuation. We have agreed, my lord, that it may be current valuation.
A net current valuation.
Yes.
Maybe also that the business can be valued inclusive.
On once a net current valuation is arrived.
Yeah, that's come. We've accepted that.
Yes, my lord.
And anything else?
My lord, then we pray, my lord, that the valuation that has to be completed, your lordships have indicated 31st December.
Where is that? Para?
My lords,
Para 11, my lords.
Para 11.
Yes, my lord. We have agreed, my lord, it can be up till 31st January.
No, not later than 31 January 2025. Para 11.
That's correct, my lords.
para 12 and 13.
Yes.
My lord, para 12.
Yes.
My lord, the direction to the petitioners to deposit a sum of 5 crores before the High Court of Telangana. My lord, they requested that this be reckoned as refundable deposit, refundable security deposit to be deposited before the High Court of Telangana in a fixed deposit, interest-bearing account. We said no problem.
My lords, we have no.
Deposit.
That's para 13, my lord.
Refundable, we'll say is refundable.
Security deposit of rupees 5 crores.
A fixed deposit.
Security deposit of rupees 5 crores.
In an interest-bearing account.
Which shall be invested in an interest-bearing account.
That's correct.
My lord, last.
Yes.
My lord, lastly, in para 12, that is little above para 13, 4 weeks thereafter may come, my lords. 2.5 crores shall be deposited within 4 weeks thereafter.
Within 4 weeks thereafter.
That's all, my lords. My lord,
That's all.
we have agreed to the same valuator, Anandam and Company, which was proposed there.
If
That has
there's
come
any
in.
other, if there's any typographical error, I'll just correct it in the order. But these
Very good.
corrections are now final.
Yes.
ये मुझे desperate डाल दो. If there's any typographical mistake.
But we've also filed a joint memo where both parties, which can be of guidance, your lordships are correcting them
All right.
with the changes.
Great.
With my last permission, may I mention?
Grateful.
Yes, Mr. Fasad.
Well, may I mention a matter? Well, this is the alderman matter where we had moved for certain directions, but then that judgment of your lordships came.
Yes.
Now all we really want to do is withdraw. Would your lordship list it for the purpose of withdrawal tomorrow?
All right. You can list
Only
it
for the
tomorrow for
purpose.
withdrawal. All right. Yes.
I'm grateful.
With kind permission, may I mention diary number 4646424.
Send an email.
What happened? Two different.
Yes, Lordship.
Yes,
But may I have my lord's leave to mention a fresh SLP of Rajasthan, my lords? This is from NGT order, my lords. The background is that, my lords, district DIAs, district environment assessment committees were, my lords, disbanded.
It will come up now next week.
My lords, it needs to be heard today, my lords. 20,000 mines in Rajasthan. Otherwise, my lords, the time was given that DI is banned. So SIA, that state committee, has to look at all of the.
When is the impugned order passed?
My lords, the impugned order was passed. This is of August 24.
Oh,
but
okay.
2 days back, MOEF had filed an application for extension of time. That got rejected, my lords. Otherwise, if MOEF would have been given some more time to process the pending applications. So, my lords, that is the problem. Lordship may kindly consider, and that application has only got dismissed, my lords, on 4th of November.
Keep it
4th,
tomorrow.
my lords, this needs to be
One
heard.
day we will go bit more matter.
Tomorrow, my lords. There
Yes,
are two more SLPs by two other
Just
states.
Give the numbers.
My lords,
Just
we've
tomorrow.
circulated, but we'll give again.
Yes.
My lords, there's one more fresh SLP, my lords, on behalf of Union of India, my lords.
Yes.
These are, my lords, two contempt orders passed by the Allahabad High Court, my lords, in a matter where compliance is already there. Would your lordship consider that also for tomorrow, my lords?
Yes.
I will just give the details, my lords.
Right.
I'll give the details.
All
My lords, there's a joint mentioning between me and my colleague. This is a pending SLP where your lordships have directed us to find a human solution for the elderly couple whose son was suffering from that. My lords, he was.
Oh, yes.
We found a solution. If your lordships would like to take that up and dispose it off, we can give home care to the to him, my lords,
Oh,
to the
yes.
satisfaction of the
Can then
parents.
keep it tomorrow?
As convenient to my lords, my lords. I
Can take it up because I remember we had requested.
we have found a solution, and that can come into force as soon as the order is.
All right, we'll take it up tomorrow so that we can then dispose
Please,
it
my
of.
lord. I'm very grateful.
And the parents have also been, their parents are happy.
Discussion, my lords. We did joint inspection. We found a solution.
Thank you, Ms. Bhatti.
Grateful.
We requested. Thank you. We'll keep it tomorrow so
I'm
that we
grateful.
can dispose.
I'm grateful.
कल वो याद है आपके पास है ना number?
Carlos, if I may just make one mention with regards to the matter that my learned senior just mentioned, the only issue is that para 142 of the NGT judgment specifically says that all mining operations across the country, pan-India, will be stopped from today, 7th of November,
Today is
as
the
on
last
today.
date.
So, Carlos, therefore, that's the only reason, my
It
lord.
means it goes to midnight. We'll keep it in the morning tomorrow. Yeah.
Obliged, my lord.
I'm also appearing in the matter, man.
Yes.
One application 38245 filed by the Arun Ramchandran Hublikar. Sir, I want to request that petition in person and also ban.
Yes, he has come here repeatedly. It was decided before Justice Bela Trivedi, right?
Yes.
He had sent the matter there.
Yes.
Now everything has come to an end there.
Okay.
What did you say?
Bishops had passed an order on 8th of April.
the board now finally at what to up. Yes.
Please, Your Lordships, this is the vulnerable witness matter. Your Lordships had passed directions on 8th of April, where uniform guidelines have to be adopted by all high courts, Your Lordships.
Right.
And those were circulated and most high courts have adopted them. But now, after the new codes have come into force, Your Lordships, those references have been changed and have been circulated by Justice Geeta Mittal. So our request to Your Lordships is to make a direction, otherwise we'll have to take compliance from every high court.
What direction do you want today?
Your Lordships, only that the new and updated model guidelines which have been given in report dated 25th October be adopted by all the high courts. That's all.
All right. Justice Geeta Mittal, chairperson of the committee constituted by this court, has sought a clarificatory direction of this court. A clarificatory direction from this court to the effect that the model guidelines.
Yes, Your Lordships, the updated model guidelines.
Updated model guidelines circulated by the chairperson on.
Your Lordships, by report dated 25th October.
By her report dated 25 October 2022.
Please.
May be circulated to all the high courts.
24.
2024 may be circulated to all the high courts.
Right.
Permission is
and
granted in terms
of them expeditiously.
Of the high courts
within 4 weeks.
Shall adopt the guidelines as updated guidelines as circulated expeditiously within a period of 4 weeks.
4 weeks. We would
From
like
the date of communication to each high court.
Please, Your Lordships. We would like to set the clock back, but unfortunately it marches on, Your Lordships. Very grateful.
Thank you. Item 2.
This is the Great Indian Bustard matter, Malats. Your Lordships have got one report with respect to Rajasthan. Gujarat, the committee has not been able to visit, Malats. So they will visit, and after Your Lordships look at this, or even independent, Malats. In this report, there is one dissent, Malats. And otherwise, the report is there. If Lordships like to look at it, I can take Your Lordships through the key recommendations.
So Rajasthan, the committee has submitted the reports. So we can accept the report for Rajasthan then?
There is a dissent, Malats. They filed objections
There's a lot
also.
to be said on this. It's going to take some time because they, for example, contrary to three judgments of this court, they have said no to diverters. So, I mean, that's very serious.
Malats,
every committee has recommended, every party has said it, and this expert committee says no to diverters. So, it will require some.
What this expert committee says on diverters is that 50% diverters are already installed without an efficacious study of it. So, please carry out a study.
Anyway, if my learned friend is defending diverters, that's all right.
To carry out an efficacious study, and only, Malats, it's a huge amount of, huge quantum of money, Malats, and that needs to be put in every now and then. So there's no point in continuing it. I'll show to Your Lordships. So there are objections. I will have to take Your Lordships through the recommendations of the committee at length. The committee, in our opinion, has carried out a very comprehensive exercise. They've enhanced some of the priority area, and they have, Malats, directed corridors to be created. Of the existing lines also, Malats, that there is a corridor at the bottom and they've suggested one at the top, which experts will have to look at. And experts have been directed from the Forest Department, Wildlife Institute, and Malats from the Central Electricity Authority for the technical aspect of it, because wildlife is one aspect and how it fits with technology is another. So these corridors will make sure that this entire area, and just last week we've had first IVF chick also born, Malats, of the Great Indian Bustard. So conservation efforts also this committee has looked at and given comprehensive directions. And Malats really to balance out. But there are objections. I bow down to my colleagues, Malats' right to object. We will have to take Your Lordships through the.
So then should we keep it on maybe after a week or so then?
Yes, you may keep it after a week. That's one option. Otherwise, subject to what the ASG says and what Your Lordships hold, we could request for the report on Gujarat if it's coming in 2 weeks, for example. This report is of September.
To be done. So this may take 6 weeks or.
All right, then you may keep it place. I mean, whatever.
So do we take Gujarat and Rajasthan together then?
As Malats deem appropriate,
But then request the committee to complete Gujarat and file within 4 weeks.
Aishwarya Bhatti, learned ASG, states that while the expert committee appointed by this court has completed its task in relation to the state of Rajasthan, the committee is still to visit the state of Gujarat and submit a report which is expected to take 6 weeks. Stop. Mr. Shyam Diwan, Learned Senior Counsel, appearing on behalf of the petitioner, states that the petitioner has some submissions to make in regard to the modalities suggested by the committee in regard to the state of Rajasthan. Full stop. It is accepted on both sides that it should be desirable that the report for the state of Gujarat, which is to be submitted after a site visit, is taken up together with this report, which has been submitted already for the state of Rajasthan. Full stop. Presently, we direct that the proceedings be listed on a specific date DJ after 6 weeks. The committee shall carry out its work in relation to the state of Gujarat in the meantime and submitted its report.
Which may be made available to all parties.
The report of the committee shall be made available to all parties.
Would your lordship consider 8 weeks, because that takes us to January?
We'll say 8 weeks. No difficulty.
2 points, your lordship.
That's all right.
Preparing for the solar power developers, your lordship, now, despite the fact of your lordship's order as well as the committee saying that the potential area, there are no restrictions on lines, approvals have not been forthcoming, saying that due to the pendency of the matter. So that your lordship may clarify that.
No, but obviously there can't be approvals just now. It's a priority area.
Pick it up after.
Exactly.
My lord's earlier judgment clarifies situations, my lords, comprehensively. Now the committee has recommended these further recommendations, but whatever is already allowed in your lordship's judgment,
right?
Go on, my lords.
Whatever has been permitted by us in our judgment should not be
permitted as such. As such, your lordship's judgment doesn't permit anything one way or the other. But anyway, we'll make our submissions now. There's no need for a...
So whatever we have permitted,
please, madam.
I mean, except where we had anticipated the report of the committee for taking...
Your lordships had constituted a new committee. You recall.
But wherever we had our judgment permits whatever, then you need not await any further directions.
I bow down, because my lords already reduced it from 80,000 square kilometers. Now this committee has taken the priority area from 13,000 to about 14,000. That's what they have said with regard to priority in Rajasthan. They'll complete the work for Gujarat also.
Second, your lordship, there's also the projects have been delayed because of the lack of approval. So your lordship may say that time extension for the project may be considered by the authorities, because they're all...
Why don't you take out some small application next time? We'll grant that extension, there's no difficulty, but just file an application.
What all these gentlemen and whatever the department...
But let them take out an application today.
Of course, and they must disclose as to what the funding is. They went before the committe and said that they will set apart some funds. That doesn't come in the final.
Instead of passing an order on an OD application,
yeah.
File something, we'll consider it. Ms. Bhatti will also have an opportunity to deal with this.
Relax. Grateful.
My lords, item 3 is the application.
Yes.
My lords will recall yesterday I mentioned this application.
Yes.
There is only one prayer that we're really seeking, that the NCRB's exercise of data collection will not be hindered by your lordship's direction regarding removal of reference to caste in the registers.
I agree, my lords, that may be necessary.
We'll clarify that. I mean, that was never the intent actually.
Very well. That's the prayer.
Just say that but NCRB should move that actually before us. Why should we do that at the behest of the petitioners?
My lords, I will also take instructions from MHA on this, my lords.
All right.
We have no objection. In fact, it will aid. They have been doing this.
The miscellaneous application, a clarification has been sought in the miscellaneous application to the effect that Direction Roman 4 contained in the judgment of this court dated 31 October 2024 shall not impact the collection of data by the NCRB, by the National Crime
Records Bureau.
Records Bureau, into brackets NCRB. Full stop. Ms. Aishwarya Bhatti, full stop. Mr. Dr. S. Muralidhar, Learned Senior Counsel appearing on behalf of the petitioner, witness Disha Wadekar, submits that such a clarification may be issued so as not to impede the work of the NCRB. Full stop. Ms. Aishwarya Bhatti, Learned ASG, submits that she also has instructions from the Union Ministry of Home Affairs to the effect that such a clarification may be issued by this court. So, therefore, without prejudice to the generality of the directions or their implementation as issued by this court, it is clarified that Direction 4 will not impede the collection of data by the NCRB.
Very great. 3rd October. That's not 31st.
3 October, not 31st October.
I'm deeply obliged.
Lord, may I seek your lordship's indulgence. We are being led by learned SG. If your lordship could take up this matter at 2, my lord. Now, there is an urgency in the matter, my lord. There's that matter wherein we have got the award of
since August the 36 SNP has been pending,
my lord.
And now just a minute, yes, and Section 9 the order has now come. Now, my lord, in the Section 9 they don't even move a 37, and they come straight in an SLP here. And
This is an order of a single judge.
In Section 9. After the award, they don't file a Section 37, but before that, they file an SLP against issuance of notice in a Section 36, where no application for an interim deposit is made.
Now, insofar as this order is concerned, let's see this for a second.
Which one, Manoj? Are your lordship sees of the Section 9 or the
Section 9?
Yes. The Section 9, the overbearing consideration is that where have you made proper pleadings that this is a company whose promoter has a net asset base of 80,000 crore and net worth of over 9,000 crores. So what is the case that you made out for dissipation? And I'll explain to your lordships how these highways function.
Let the SG
No, I have no difficulty. Since your lordships put a question, I answered. I have no difficulty. I'll be here to assist your lordships.
An award has been virtually set aside in a Section 9.
No.
Please.
Anyway, we'll take it up. When should we take it up? You tell us.
2 o'clock.
Could it be today or could it be Monday or Friday, whatever I want to say.
Spare 5 minutes.
If you want, we can take it up on Friday, or we can take it up on
tomorrow.
Or we can take it up on
Monday, my lords, could it be?
Keep it on Monday.
Yes, very great.
Yes.
Great.
4 and 5 are connected.
4 and 5
are connected.
Great. 6 is that matter about those people with benchmark disability. Can I take 5 minutes, or would you like me to address at 2 o'clock or tomorrow? Whatever suits me, because we have been waiting. 7 minutes by the clock, 7 minutes.
Am I audible, my lords? My lords, the 2 candidates, my lords, whom my lords permitted, they have been selected. My
That's exactly because my lords, the Chief Justice intervention actually has helped 2 people, my lords.
We'll take it up at 2 o'clock.
Take it up at 2 o'clock. Before the RG car matter.
Yes.
We are grateful.
Though they have been selected to the judicial service.
Those 2
They have
people
been
have been selected. So
They have been selected.
And because our lordships intervene, therefore I am just seeking as I might have some guidelines.
They are both visually challenged. No?
Yes, it does. And one is visually challenged, one is also. Just imagine if others had got in, what would have been. So I was seeking some directions which can be followed all over the country.
All right. Okay. Have you formulated something?
I formulated something. In fact, I told Mr. Raju sir is not there. I in fact requested Raju sir because it need not affect the ongoing recruitment. But for future mirrors, it has to be just 2 directions I was seeking.
All right, we'll come back.
2 o'clock.
Mr. Ramachandran is in some difficulty.
I have also filed my written submissions for it.
Check. Check.
Check, mic check, 1, 2, 3, 4, check.
Yes, sir.
Those two blind candidates, they have qualified. What happened exactly?
So, they have been in the select list. They have been taken in the select list. So, effectively now their appointment process is the only thing pending. So, your Lordships may note that in those two matters, which are today item 8 and 9, that they have been brought in the select list pursuant to the interview. So, they have been selected. Now, the admission formalities so that their appointment is taken on board will be completed. That's all.
Who's appearing for the High Court? You're appearing for that. Take them now, issue appointments to them.
Well, subject to the normal procedure because IB reports, etc. will have
to. Oh, of course. And
subject to the normal verification and procedure.
We can just pass the order. Now, which is the matter where we get that? We'll just dictate a short order.
Let's take up item 9, Manoj. That order will come from there.
Bill number 9, right?
So 8 and 9.
So 9 will dictate the order in 9 and 8 is to be tagged. During the course of the hearing, the court will be apprised of the fact that learned counsel appearing on behalf of during the course of the hearing, the learned counsel appearing on behalf of the High Court of Rajasthan has stated that 2 of the candidates, how many were there totally in the interview? No,
only 2 your Lordships had permitted and the 2 have been selected pursuant to the interview.
The 2 candidates who were permitted by this court to participate in the interview.
Correct.
Into brackets, what are their names?
Plus Siddharth Sharma and Tishan Jangi
have qualified, have been selected for the post of
junior
civil judge, and their names are born in the select list. So stop. In view of the, in regard to the above development, we direct that that letters of appointment shall be issued to the above 2 petitioners, subject to compliance with usual formalities, which are applicable to all other candidates, save and except the issue of disability.
Yes. So 8 and 9 can be disposed of with this now.
So yes, the 8 and 9 will dispose of. Good. We have 2 candidates who are suffering from physical disability who have made it. God knows how many else didn't actually apply because of his.
My lords, we are very grateful to your Lordships for your intelligence, my lords.
Plus items, so firstly on 8 or 9, they were really on the moon after they got in, and I can't express. Personally, I met them and they were very, very excited for what awaits them. Also, in 7,
to the judiciary, it's such an important thing that these people are also now in the mainstream,
Absolutely.
And their thought processes get reflected.
Of course.
I mean, it's not only persons with disability who get in. When they pass judgments, when they move forward.
Others regard disability very differently. When they see these candidates working, doing well.
Right.
Now, tell us any further directions.
Yes, I have in the lunch breaks, Shraddhan, myself, and large number of others have made those 3-page submissions. Well, why this problem arose? If I indicate,
now,
I'll not take more than 5 minutes.
You may. We'll take them on the record.
Yes.
But they will now govern which matter because 8 and 9 we have disposed of.
That's the suo moto matter.
Right. That was
I'm assisting your Lordships as a
the suo moto.
Yes, and it's not for ongoing vacancies, ongoing recruitments.
Right.
This will have to be a futuristic thing. Because why this problem arose, Manoj? I'll just indicate why this problem arose. This problem arose because there was no separate qualifying marks in the preliminary exam for the persons with benchmark disability. So if you didn't fix any qualifying marks, then you ended up comparing them with general category, OBC category, SC category, ST category. As a result, because not enough people actually made it to the main exam. So just to give your Lordship's figures, 9 vacancies are reserved for persons with benchmark disability, but only 11 made it from preliminary to main because there was no qualifying marks. That's why my Lord Justice Bila Trivedi's judgment says, see, in absence of qualifying marks, I can't help it. But fortunately, my Lord, the High Court and the state of Rajasthan have now prescribed the qualifying marks of say 40% in the preliminary examination.
For the PWD candidates.
For the PWBD candidates.
PW?
A benchmark disability. Yes, obviously, Milos. A PWD or PW, same Milos. Now, Milos, this is, and therefore, Milos, this completely changes the spectrum today. So, Milos, therefore, I had 3 very simple suggestions which are.
Let's read your suggestion and we'll get a short order.
And this can we have futuristic, high courts can look into it. High courts can come back if there is a problem, Milots, because it has to be futuristic. High courts or public service commissions, while some exams are held by PSC,
public service,
while making recruitment to judicial service, ought to provide separate qualifying marks for persons with benchmark disability in the preliminary exam. The qualifying mark should ordinarily be the same as SC/ST candidates or can be lower if so prescribed by the relevant rules. If the rules are silent, then the competent authority can lay down such qualifying marks.
Yes,
Right.
the first.
So 40%, 45%, I'm not saying lower than qualifying. After the preliminary exam is held, a separate cutoff. Now, this is not qualifying, this is a cutoff. Cutoff should be prescribed for persons with disability to ensure that candidates equal to 10, 15 or 20 times the number of posts reserved for PWD candidates are eligible to take the main exam. Stopping here, some says 10 times the number of vacancies will be called to the main exam. Some says 15 times the number of vacancies will be called. That's why I've said 10/15/.
That is the discretion of the High Court.
That is depends on the rule, my lords. Your recruitment rule says 10. So suppose 9 posts are reserved in Rajasthan, 9 posts were reserved for persons with disability. 9 into 15, 135 persons with disability.
Or it can be the same as for the open category.
Therefore, this PWD should be as a separate class, Milots.
All right.
That's
You're saying have a and ultimately they have to all clear the exam.
That's right, Milots. It's only eligibility to take the exam.
All right. Then.
Right. Now, Milots, this is an additional caveat, Milots, and this came from Jharkhand. So just stop here for a minute. After Milots, the Lordship judgment in Rekha Sharma, I as amicus wrote to all high courts. I have got responses from high court saying we have a separate cutoff. Not only we have a separate cutoff, we have a separate cutoff category wise. Because 34(1) now says for blindness there is 1%, for locomotor there is 1%, for hard of hearing there is 1%. So in fact, your lordships will see my submissions at page 28. In
what we'll say that the high courts would be at liberty to provide a separate cutoff. That's all that we'll say. We'll not impose it on them.
Not at all. Therefore, this can be considered, Milots. Yes, Milots. Now this is till the preliminary, Milots.
Yes.
Now I am coming to mains, Milots. 1 and 2 deal with preliminary. We are now done with the preliminary stage. High Court PSC ought to lay down separate qualifying marks for the main exam.
Again for mains.
Again for mains, Milots. This is what happened in Sadan's case. There was a mains qualifying marks now kept for the main exam for PWD, which can be same as SC/ST or even lower if so required by the rules. If the rules are silent, competent authority can lay down qualifying marks. While declaring the result for the main exam, a separate cutoff should be prescribed for PWD who have the qualifying marks. I'm never saying lower the qualifying marks, who can appear for the interview, so that sufficient number of persons belonging to PWD can take the interview, which is normally 3 or 5 times the number of vacancies for PWD candidates. At this stage, also the recruiting agency may be able to follow the bifurcation under 34(1) of the Act. So suppose, Milots, just giving an example, suppose there are 4 seats, two seats reserved for visually handicapped persons. 2 seats are reserved for visually handicapped persons. 3 times the number of vacancies, that is 6 visually handicapped, 6 orthopedically handicapped, 6 hard of hearing handicapped, etc. can be called for the interview, subject to them having the qualifying marks. Now, Sadan's case, exactly what happened. They had the qualifying marks, but High Court did not call them for the interview. And therefore, your lordships had to intervene. And your lordship's direction, they took part in the interview. Otherwise, they would have just lost it. So they had the qualifying marks because the High Court did not provide a separate cutoff for them. They said, you now meet your general, you meet your OBC, you meet your SC/ST. So if you have prescribed the qualifying mark, if the person meets the qualifying exam, then subject to 3 times or 5 times. Some Patna High Court has 5 times. I think Rajasthan High Court had 3 times. 3 times the number of vacancies you call. So if you have 9 vacancies, you call 27%.
The problem in Rajasthan was that the cutoff which was prescribed was that for their category.
Their own category.
Their own category.
Yes.
Whether they are open category or SC, ST, OBC.
May I clarify at this juncture something?
Just 1 second, Mr. Rungta.
I'm on the last. Now, after, and this is very important, Milots. After the interview at the time of final selections, PWD candidates who have the minimum qualifying in the main exams and the interview ought to be recruited to the service based on horizontal reservation. Because the reservation is horizontal. So suppose 9 persons, 9 vacancies were there, 9 persons made it on their own merit, then there'll be no requirement for reservation.
Right.
Suppose 3 persons made it in their own merit, 6 will be recruited. So that is what I have said, Milots, so that the vacancies are filled up. If there are no available, my lords, then of course the consequences go.
What we'll do is we'll issue a general direction in terms as you have sought. In the evening today, when the order is typed, I'll just give it a little tweaking.
Sure, my lord, sure.
So, since we have to start Ajikor, we'll just take this as a direction.
Right.
Because this will really ensure that the disabled candidates actually come into service.
My lords, I'm very grateful.
Otherwise, we have the reservation, nobody is available.
Absolutely, my lord. So this is as far as suo motu is concerned, my lords. There are two writ petitions which my learned friend wishes.
Further orders.
Can I just make one submission?
Just 1 second. You're on the same page as him. We'll then, if there's something additionally, we'll take it down from you.
Yes,
yes, Mr. Rumta, all right, tell us.
No, my lords. My lords may dictate if.
Right. Pending further orders, we are inclined to issue the following general directions, which would govern the selection of candidates to the district judiciary across the country, full stop. These directions shall be observed by the high courts or where the public service commissions carry out the recruitment on behalf of the high court by those commissions.
Just one more thing.
If then copy down 1 to 5 from, मैं शाम को थोड़ा उसको click कर दूँगा.
Sure. So that this suo motu lordship can have it after. This can apply to future, so that
a copy of this order.
Yes.
Copy of this order shall be circulated to all the secretaries general, all the registrars general of the high courts, so that they can be placed before the concerned, chief justice and the committees in charge of recruitment to the district judiciary for compliance.
Item 7 is a fresh matter.
For compliance prospectively.
Yes, that's.
Now, my lords, can I request, my lords, for one addition, my lords?
Yes, Mr. Rumta.
Only to clarify these, in order to clarify the position, my lords, it is necessary, my lords, may also observe that vacancies reserved for persons with disabilities and each category of disability are separate class of vacancies as per rule 11 of RPWD rules 2017. My lords, the problem arose in Rajasthan because of the fact that they treated.
Rumta sir, just a second, sir.
The court is conferring.
Court is conferring, sir.
Sorry.
Mr. Rumta, we are just passing this order. Let's see how this pans out in the next 6 months or so.
My lords, only
get some people into the.
No, my lords are right. I was just pointing out, my lords, which is very necessary in accordance with the rules, my lords.
But this, your lordship, in the 2410 order, that Om Rathore order, your lordships have already said that, what he wants.
Yes. No, so that's why I am saying that it should be made a part. Only that, my lords. So that, my lords,
what clarification would you require, Mr.
Rule 11 of the.
My lords, Rule 11 and Rule 11 of Central Rules says that these vacancies form part constitute a separate class of vacancies. It has nothing to do with the community to which we will belong. The whole problem arose because the disability was interlinked, reservation of disability was interlinked with the community to which they belong. And that is why no separate cut-off marks was given. That is the problem, my lord. The category was interpreted to mean.
The order which you are passing will cover it, Mr. Rumta.
No, I am saying, my lord, in the final order, in the final directions, just clarify, my lords, include that part of the order.
My learned senior colleague is referring to 11.4, which is there on screen. Reservation for persons with disability in accordance with 34 shall be horizontal and vacancies for persons shall be maintained.
We can clarify.
As a separate class.
We just say reservations for persons with disabilities shall be horizontal in nature and vacancies for persons with benchmark disabilities shall be maintained as a separate class.
As required by
yes.
We will not say as required. We are using a 1 foot.
Item 7 is the.
My lords are right. I will go down.
You make it work on the ground, because otherwise.
So far as Rajasthan is concerned, my lord, because of the judgment of Honorable my lord Justice Bela Trivedi, my lord, that holds that in view of the rules of the RJS rules of the Rajasthan High Court, No separate cutoff is required to be published. Now, my lords,
The High Court shall be at liberty to now to bring their rules in conformity with these
Yes.
guidelines.
So grateful, Your Lordship. So
Item
grateful.
7 remains on this issue.
We
are 1, 2, and 3.
And report compliance. And report compliance.
That's why, my lords, I wanted to bring it because unless the rules are.
I can give you 20 reasons to deny relief. There should be one good reason to grant relief. You know,
Yes.
My lord,
Once the rules are in
3 also remain in the on the same issue.
Item 7 notice has to be issued. I'll just in half a second explain, Malaz.
We'll issue notice.
I'm grateful.
It's also disabled.
Next week or next to next week. I'm grateful.
My lord, 6.2 and 6.3 are also on the same issue. These were petitioners who were not allowed for the mains examination, but the problem arising was the same.
All right. But now, a notice has not been issued in your.
Lords, pleadings have been complete in this in these particular two.
Then it has to be heard. It will be heard.
My lords may have it.
It will be tagged with the suo motu matter.
It is.
They are already tagged. Yes.
6.2 and 6.3.
We'll keep it after 2 weeks now.
2 weeks once. Grateful to
the court.
Grateful, Your Lordships. Grateful.
Now we'll take Abzu talk. Let's look at the status report and see what has happened.
I apologize on behalf of the learned Solicitor General. He is in an overnight part-heard.
All the better you are there on your leg. We'd like to hear you now.
It instructed me to hand over the status report. I'll just do that.
Yes. It's always good to give juniors a chance as well to be.
My lords, the charge stands framed.
This one, taking it. Before we hear you, I'll just give me 2 minutes only to dictate. Otherwise, at the end, we are running short of time. The status report, the 6th status report is 13 August 2000, dated 5 November 2024, filed by the DIG, stroke Head of Branch Special Crime -1 CBI, indicates that on 4 November 2024, the Additional Sessions Judge, First Court, Sialda, Kolkata, has framed charges for offences punishable under sections 64, 66, and 103(1) of the BNS 2023 against the accused Sanjay Roy. Full stop. The next date of hearing has been fixed on 11 November 2024. This part we have investigation in respect of other aspects is continuing. Since in view of the continuing investigation, it is not appropriate to make any detailed reference to the nature of the investigation which is being carried out at present. I shall keep this court apprised of the further status of the investigation and the criminal case by the next date of hearing after a period of 4 weeks.
We are very keen, Manoj, that this case be taken forward very quickly, Manoj.
Yes.
Yes, that's very
Before
important.
the other side,
Now the next date is was
Monday
the
itself.
Monday.
This should be, because the state believes that as quickly as possible, Manoj,
Right.
the person who is involved should be punished.
Right.
On the last date, my lords had passed an order to the NTF to give a report.
Yes.
That report has been filed by the NTF, by the Union of India to the NTF.
Do you have a copy?
Let's say it is on record, but we are carrying copies. I can pass on the copies as well.
But that would
We have copies as well, ma'am. Will be shared with everybody.
Certainly. Let's see the report. Yeah.
Outside my lords, I'm just
Not at the top. Nothing to us. So necessary.
Soft copies and hard copies.
let's a minute. It was with the Solicitor General's files. I'll just collect them and pass it on. The entire report has been put on record, and the report has 3 subcategories. It categorizes short-term measures, medium-term measures, and long-term measures, and it provides a conclusion. The report may be placed before the union government and before the state governments and the UTs for further action. That is the conclusion of the report.
We'd like to offer comments on the report. We are the affected community.
Of course, no difficulty.
It is
Just
fine.
let us see the report there.
Executable.
Certainly, it is filed as an affidavit and it was served to all parties, and it is also there in the office report. For some reason, it is not on record of the court.
I think it was
I'll just
served,
let-
unfortunately. But we
It's not here. It's not with us at all. Even the court master says no.
I'll just procure.
Do you have a copy?
Well, I just have one copy.
Give us one copy. The 3 of us will come closer and share it.
It's in the name of the affidavit on behalf of the Union of India, because the office report.
Well, my learned friend may clarify, is this the final report? The interim
report by the end.
Is it?
Well, it's
NTF.
paid
You flagged it as NTF, right? Okay. Information.
Excuse me. Okay.
No, nobody. Hold on. This is our part. Say something.
the National Task Force constituted by this court has submitted an interim report, right, Mr. Agarwal?
Please, my lord.
Has submitted an interim report. Full stop. The report that the NTF has formulated its recommendations in two categories, bracket 1, prevention of violence against medical professionals and providing safe working conditions, and 2, prevention of sexual violence against medical professionals. Full stop. For the purpose of implementation, the recommendations in category 1 have been classified into those which can be implemented in the short term, medium term, and long term. Full stop. The NTF has suggested that all the measures should be adopted and implemented by all healthcare institutions into bracket HCEs as well as states /UTs. Next, in order to enable the court to issue direction for compliance with the recommendations of the NTF by all HCEs and states /UTs, we consider it appropriate to direct that a copy of the report shall be made available to all the counsel appearing in the present batch of cases, and to stop. The report shall also be supplied to the chief secretaries of all the states /UTs. Full stop. In the event that any state /UT intends to make any submissions in regard to the recommendations, a brief note of submissions may be filed. Soft copies of brief notes of submissions may be filed through the Standing Council for the states /UTs to the court master. And then we can say that this exercise shall be completed within a period of 3 weeks. We'll give 3 weeks to the states. Otherwise, no state can say we didn't give you an opportunity to respond. Otherwise, these are comprehensive recommendations. At the interim stage, we'll ask the states and UTs to start implementing these directives.
There's a request, my lords may not say interim, my lords may just say a report, because I'm orally informed that the NTF believes that there is significant material in this, and if required, the NTF will make further.
A report.
Say a report.
My lords, in that case, we can also be given liberty to submit, make a submission.
The report has been agreed upon by all the members of the NTF or only a few of the members?
That is what I understand. It is agreed by all the members.
Because it doesn't bear the signatures of all the members.
My lords, the officers are here and they are stating that all the members have agreed to the report and only thereafter it has been placed on.
All right. The original has the signatures of all the doctors, right? Because we just want to make sure that we have deliberately included a combination of private and institutional experts in the NTF. We want to make sure that both have agreed to the report.
I'm informed that it is a report by the entire committee and everyone has agreed.
Okay. Now, Ms. Jaising, pursuant to what you said, Mr. Sibal, we'll ask them to disclose the report. You have a look at it. If there are any concrete suggestions, we can always hear them.
My lord, I have a couple of suggestions of
All right. Now, this part is okay. This part is done now. Now, what else now?
May I please be allowed to make a submission? My lord, I've briefly gone through the report. There are 2 or 3 aspects which I would like to draw your attention to. Number 1, though a lot of suggestions have been made, no monitoring mechanism has been put in place, and we will put this on record, because at the end of the day, it's all about implementation. Now, just hear me for a minute.
Jaising, can we just suggest one thing? The report has come on the record. If you have some suggestions in regard to tightening up the implementation mechanism or the enforcement mechanism, give us a short note. Because when we are dictating an order, it becomes all the more easier rather than...
Your lordship may not direct to implement it right away till you see the submissions.
So we are not saying, we are not ordered that. We have just said disclose the report so that you can then make concrete suggestions.
Secondly, my lord, most importantly, there are some very important stakeholders who are not present before this honorable court among the people represented here today. May I please request that they may be added, because the problem, my lord, is with examination and with the examination, so the university is not represented. All these hospitals are ultimately accountable to the university, to the health university, whose statutory duty it is to monitor what's in this report. So, my lord, they may be added as parties to these proceedings,
But
and this
what
report
will
we
happen
should
is
them.
that will become unmanageable because every state has its own. We have the chief secretary.
But I'm concerned with West Bengal.
They will do whatever requires to be done by the state level, but we will have one state government.
In fact, each state may have a different perception in the context of the peculiar situation. Therefore, you should allow the state to place facts.
The states can then circulate it to their universities. For instance, in Maharashtra, I know you are the Maharashtra University of Health Science.
This is where the doctors become stakeholders. What happens is they do what they want to do unilaterally. Where do we get a voice? My question is only that.
Ms. Jessing, you are representing the doctors.
Yeah, but I cannot.
We have formed.
What goes on inter se between the state and the university? I'm not party to that. I'm not party to that. How do I become a stakeholder?
But
there is a state task force appointed in which doctors are senior doctors.
I'll tell you the problem.
No, senior doctors are not there.
Just one second. Assuming what you say is right, and we have no reason to disregard it, we now are going to look at you as an important stakeholder. So whatever suggestions you have on the report, we will look at your suggestion. Therefore, give us a short note. If you feel that the report has to be strengthened by your suggestions, we'll incorporate those suggestions.
Grateful, my lord. That can be recorded.
I just said that.
My lord, I think our submissions being given.
The council appearing on behalf of the different stakeholders, including the associations of doctors,
Senior doctors and junior doctors.
Senior and junior doctors, would also be at liberty to file short their notes of submissions on the way forward in the context of what has been suggested by the NCRB.
Muraz, I'm sorry, I didn't want you to just give me a minute. At page 12, Muraz, of the report itself, they are the part of the before NTF.
No.
Is there.
But 1 second, Mr. Kapil Sibal, please listen. Milord, it is true. I read it.
Can't compete.
I have read it, Milord. The problem is that they nominate anybody they want on our behalf on these committees.
This is the NTF report, not ours.
Of course, that we want to nominate our own representatives. You cannot nominate me.
Election should be held.
Nominate my representative on your committee. I want to nominate my own representative.
Therefore,
and that is not clear in the report, Lord, of the task force.
You are here assuming you were not heard. Some of you are not heard by the NTF. We are here before us now. You give us your suggestions.
We will give you our nominees, my lord. We will give you our nominees on this.
We don't want your nominees. We want your suggestions. Your
suggestion is nominate us. Allow us to nominate. We don't want the state to nominate us, Lord. We don't want the state to pick and choose nominees. That's where the problem lies.
We want to hear you. You are before us.
The right of self-representation, my lord.
Of course, therefore, we are hearing you now. You give us your suggestions, and we'll be happy to take whatever suggestions, constructive suggestions are made. And we have given that opportunity to all of you appearing on behalf of the stakeholders. So please give us short submissions that the report can be strengthened or there's a lacuna. This aspect has to be looked into.
We'll do that, my lord. My lord, another issue that can be dealt with quite easily.
With so many council, you can never find a way forward.
You know, what ends up happening is we say it's not implemented. They say it's implemented. There has to be a third party to look at what we are saying, or they're saying who's telling the truth.
But therefore, the monitoring mechanism.
Yes.
You are absolutely right. On the monitoring.
Independent monitoring mechanism.
Yes, Ms. Jaising, absolutely. So
we are in support of that.
Just 1 second. So you suggest to us how an independent monitoring mechanism can constitute it now, not just West Bengal. We are looking at it pan-India.
It has to be pan-India, my lord.
So you can put your brains together for all the doctors and tell us what kind of monitoring mechanism we can envisage to implement these recommendations and to ensure that the implementation has taken place. Because we can't sit here and look at every different.
My lord, I understand. That's all my suggestion.
So we are with you on that. We are with you on that. But just make that complete.
The states, they can't monitor themselves.
My lords, perhaps that could be recorded.
Neither doctors run the state. Let's leave it at that. Let's get.
My lords, can that be recorded?
No, let's get on.
My lords, my lords, given that this is a large matter, and there will be orders that will need to be dictated.
About it.
I never said anything to you. Why?
No, innuendos say more than what you say.
I never said anything. I said leave it at that. That's what I said.
And that means leave Ms. Jaising alone.
My lords, what had fallen from my lords is extremely helpful, which is that if my lords may record that an independent mechanism may be proposed by all the stakeholders for the doctors.
I don't want to confine you only to that, Karna. We want you to give us an overview of what your perspective is. This will be one aspect of your perspective. We don't want to confine you only to this, to an independent monitoring mechanism. Give it to us in writing, we'll certainly implement it. But we want you to, therefore, you are all doctors here,
yes,
the seniors and juniors. Give us your concrete suggestions. If we have, say, 10 sets of suggestions, we'll put them together. We might even tell one council to give us a comprehensive set of, the common suggestions, and then make them a part of our order. That we have to also find some sort of order in this large group of lawyers.
We'll do it, Lord, set a date for that.
Absolutely.
Your Lordship.
This is of AIMS Doctors, Resident Doctors Association. What has happened, you also recall, on 22nd August, your Lordship said everybody should get back to work, no coercive proceedings will be taken.
Yes.
RD of AIM, the same day evening, we joined back to duty pursuant to your Lordship's order. Now, AIMS Gorakhpur, AIMS Kalyani, AIMS PGI Chandigarh, those directors have passed an order saying that those 10-12 days of strike will not be counted as leave, they will be considered on duty. Now, AIMS Delhi, they gave a representation. Surprisingly, AIMS Delhi, those 12 days has been taken as that we are absent adjusted against our leave. A leave has been deducted. I have annexed that, my lord. I have annexed the IA.
Look, if you start going to individual healthcare establishments, it will be impossible. What we suggest is this.
Yes, my lord.
A representative group can meet Dr. Shivras, who is the director at All India Institute of Medical Sciences, Delhi.
Yes, ma'am.
Have a word with the learned director. Once, he's assured that, look, all the doctors are come back to work.
Yes,
I'm sure by and by he'll take a...
May I just respond one second?
But it can't be, that
The
we don't want to
doctors
hold
must
him.
start working, my lord.
We also don't want to hold him to the point.
He's a very helpful person.
May I just respond to that?
What to the point of a gun by telling him that, look, you better do it. Let there be a little bit of mutual understanding between the doctors and the director.
May I just respond, my
because you must also show your good faith.
No.
One second.
Yes.
Go and tell him that, look, we have now resumed duty. Can you not take a proper view of this? He will take a proper view of this, provided he is satisfied that the doctors are on work.
May I just respond? We've done that. That is what we've come to Lordship, not at the first instance. We gave a representation. They formed a committee. We annexed all the orders of Kalyani, Gorakhpur, PGI, Chandigarh. Said, please treat us same way. All of us struck work together. All of us got back the same day. Now, even after that, an order is passed. On 2nd November, we got it yesterday, saying that AIMS Delhi, so now what is happening is AIMS Delhi, those doctors are considered as on leave. Other AIMS, they're considered as leave will not be deducted. So I'm not coming to your Lordship at the first instance. I'm coming to your Lordship after.
Let you file an application. Today, AIMS is not even before us, that we could ask a council, what is the problem? File an application, we may then ask somebody to respond. What is the
filed it, my lord. That's why I'm the last resort. I'm coming to your Lordship.
All right. Now that you have flagged it, now what you do is that you can meet the director at AIMS, say that let's try and sort it out and see what the difficulties are. Many of these things have to be sorted out with a little bit of. Those directors are there to make things work. They need the doctors more than anything else.
Not after 23rd August. One sec, please.
Anyway,
after 23rd August,
we've made ourselves clear.
Yes, my lord.
Do meet the director of AIMS and request him to take a sympathetic view now that the doctors have gone back, and we'll see on the next occasion what be on work and be on duty. I'm sure things will get sorted out by the next day.
At least same day, Lordship passed the order. We're back on work.
You still have 2 months for the end of the year.
No, I tell you why.
Don't worry about the leave.
I'll tell you why we are concerned. Many of these doctors, if they've taken a period on leave, many of them have to extend their tenure. Can't apply. That's why we are concerned.
We got the point. We are with the doctors. Rest assured that we understand these problems of the doctors. Just talk to the director, we'll sort it out. All right, we'll take up the application next time and give a short notice to serve a copy of the application on the standing council for AIMS. I think I don't know who appears for AIMS now. Mr. Vikrant Yadav used to appear.
Yes.
Find out.
Would your Lordship at least record sympathy, something, so that I can go to the...
Give it to Mr. Vikrant Yadav and follow him.
Your Lordship.
Well, there remains...
You don't want to run these hospitals. They know what the problems are.
Yes, obviously.
Yes.
Yes.
Your Lordship, I just want to
perhaps in some order.
Now, I think we have...
Yes,
Your Lordship, I just want to make one submission.
May I just say one thing, Manoj?
One submission.
There remains a rather significant issue of the police commissioner violating the identity of the victim
with a Calcutta.
My lord, that matter is pending at the High Court, my lord.
Said
My
last
friend
time-
brings it,
Right
my
now,
friend brings it
Your
up every
Lordship, I
hearing.
just want the last occasion, the
Say the
Lordship
same
will
thing.
deal with it, my lord. I'm at this
The
important
High Court
issue.
is
behind
Yes,
it.
we are not closing it.
cognizance
We're not
of it.
closing it.
All right, my lord.
Your lordship, I just
So quickly.
one subject.
Can't be closed so quickly.
Just one.
My lords, there are some remaining issues that need to be wrapped up. So therefore, for example,
Put it down in the, or put it down in the form of a note and give it next time, so we can deal.
but my lords, this is not with regard to
No,
the NTF.
We can't be passing orders on, offhand oral submissions. Give us something in writing.
We do have it in writing, my lords. They have filed
What do you have to say?
an affidavit and we have filed a reply.
My lord, in so far as the main case, sorry, the charge sheet. My lord, they have not produced the charge sheet before your lordships even till date. 90 days of investigation, what they have done is nothing. They have just endorsed what
My lords,
was
I will
done
have something
by
to
the
say. This
Kolkata
is the
police
trial about to commence. He is a
for
straight
5 days.
We are not going to it.
But there is
There is a
One
charge
second,
sheet
just 1 second.
filed.
Charge sheet has been submitted, charges have been framed.
Yes.
But
The
then
trial
that's
judge, one
that's
second, just 1 second. The trial judge, who's a district judge level officer, he has sufficient powers. He has sufficient powers. If he feels that further investigation is necessary, he will make that direction.
Absolutely.
We don't want to run that task ourselves when this is something which pertains to the role of the district judge.
My lords,
But
Now the prosecution evidence is going to begin. When he sees the evidence, he has ample powers as the presiding judge
he said that it will continue the investigation.
and we made that clear in our order today.
And he has powers under BNSS to alter the
Yes,
charge.
that's what we are saying.
Because this kind of
So 1 second, we are not doing that for the reason because then that will only dislocate the trial.
That's right,
Because
that's
the
right.
trial judge will say the Supreme Court is seized.
Yes,
of it.
yes.
I have a submission.
an order passed. May I just, there is an order passed for recording of evidence.
90.
For the time.
Your lordship, the trial is about to commence. The trial may be shifted out of West Bengal, keeping in view the disturbing features in the case. But
My lords can
Amala, from day one,
the trial, neither can.
there are precedents. There are precedents.
I know there are precedents. We have shifted the trial, some trials out of Manipur, for instance, to Assam.
Muzaffar,
Here we are not doing it. We have let the trial continue before the district court. Otherwise, we'll be casting doubt on the legitimacy of our own judicial system. We have nothing to do. We have nothing to do.
I'm sorry,
Disparities. I'm not on the rape and murder.
1 second.
There is an attempt to solve the trial.
The investigation goes beyond rape and murder.
Ms. Jaising,
Yes.
the status report which has been submitted by the CBI has extensively referred to the investigation with regard to financial irregularities. We don't want to flag any issue because that might possibly dislocate the investigation. Please rest assured that CBI is looking into financial irregularities
But
also.
this is
They have
the part
flagged
of-
various aspects for us.
SRC.
My
The part
lord,
of another
it's a matter of concern that
And-
people who are strangers.
They have not even asked for
Somebody wants it shifted, somebody wants it stalled.
We are not doing anything like this. We are not doing, you're right, we are not doing
Very
anything
grateful,
like
my lords.
No, Maharaj, it is self-contradictory. On one hand, you are saying there is a sole accused.
that. Look, I don't want either your comments or your gratuitous comments as to whether we are self-contradictory. You reserve,
I'm not
you reserve, you reserve
But
it
I'm
for the
saying
television.
CBI is self-contradictory. Maharaj, on one hand, they are saying there is a sole accused person.
My lords, the question is, who does he
Another
represent?
person.
Who does Mr. Adulji represent that he seems to think that this is self-contradictory?
The charges have to be reframed.
Who does
Again,
Mr.
there should be a
Adulji
retrial.
represent?
Strange,
Are you not interested? Are you not interested in the trial? It appears that there are factions we don't want the trial to proceed. Let the trial start. Let the trial just take charge.
Order has been passed for recording of prosecution evidence on a day-to-day basis from Monday, 11th
That's
of
what we
November.
want.
Why is there interest in strangers to stop that?
We are not,
Absolutely.
we are not going
Absolutely.
to stop it at all.
When the supplementary charge sheet is filed, if required, there is power to alter or amend a charge. That is the power under BNSS, which will be exercised if required.
And
All right.
Deeply obliged, Maharaj, deeply obliged.
My lords, there are a couple of issues that my lords had been seized off from the beginning.
Next time.
Maharaj, the third part is
But my lords had taken a particular interest in these issues.
Your Lordship, can I make one submission? Your Lordship, can I make?
My lords, it's just the Rati Reshati. The threat is now.
Your Lordship, can I make one small submission, Your
Let the
Lordship?
trial start, we'll do
Your
all
Lordship,
the other issues separately.
Your Lordship, I'm appearing for Delhi Medical Association. You have two submissions regarding the compensation scheme, Your Lordship, and the expediting the trials of the violence against the doctors pending in all the pan-India, Your Lordship.
Just come with a small note of submission.
Yes, Your Lordship.
Lordship, one submission.
Much obliged, Your Lordship.
People in West Bengal have lost faith in administration and judiciary, and hence averting most tourist holidays.
Don't talk about the people. Talk about who are you appearing for? Who are you appearing for? Who are you appearing for? Tell us the name of the person. Nobody. Just canteen gossip here in the court. Tell me the name of your client. When you say people of West Bengal lost faith in the judiciary, somebody has to put his oath to that statement. And make such...
And orally off the cuff. Orally off the cuff.
You're not even appearing for a client. Yes.
But may there's one small thing we are seeking that had fallen from my lords. The idea of us proposing a commission that could oversee all of these recommendations. So if this could be recorded, my lords, we'd be extremely grateful.
My two learned brothers are going to be part of the bench, so they will remember that. Yes.
Very well. We'll be relying on Justice Pardiwala.
Can I just say one thing, Lord? Lordship has asked all the states to give response and all of the parties to give response. Lordship may ask one of the members of the bar to correlate everything and Lord give a comprehensive thing.
We'll pass that order. We are going to do that. We always do that. One learned counsel, usually we pick up a junior counsel who will put everything together. We might last time one bit. So one other person from this side.
My lord, Sharma from the state.
May I only submit one thing, my lord?
Next.
My lord,
Next.
May I only hand over one document, lordship? I don't want to waste it.
That document should get lost in papers here.
Because, lordship, this is very seriously how these civic volunteers, lordship,
the
lordship has
we have passed that order.
That civic volunteers are interfering in the administration of justice, my lord.
Fair enough.
This is one disturbing document, lordship.
Yes, we will see that.
Kindly consider this.
My lord, item 10 is that application, my lord, by the Municipal Corporation, Greater Mumbai, my lord, for that, my lord, median landscaping, my lord, in that coastal road.
Yes.
But your lordship had considered this application earlier, my lord. I've been instructed to respectfully submit.
Now, what are you planning to do? You're planning landscaping. We can say there's no difficulty.
Have a look at that. This is what is.
All right, sure. Give Mr. Singh also some photograph.
Give me a copy. Yeah, please. But the middle part, my lord. पूरी होगी 70 kilometers or 10.5 meters.
Oh, your lordships, take this up.
Can I just make a...
So, where do you want to actually do the landscaping?
Before your lordship take this up, I have one request to make to your lordship. Before you hear this application, after the 17 December 2019 order, which is an interim order allowing them to secure the road and carry out only the reclamation, October 2020, they made an application. At that time also, we requested that these SLPs should be heard immediately. Instead of these interim orders. Then in September 2022, they made an application for further modifications. And again, we said, and your lordships had indicated that the SLPs will be heard. Now, we are in 2024, and these SLPs ought to be listed and heard. Instead of this, what is now they want to give a 30-year contract in a pending SLP where there's a judgment.
Now tell us.
I'm saying that this is a matter your lordship can list it in January, and here the Bombay High Court judgment may be set aside by your lordships on merits, or it will be affirmed.
One thing, which is that area in which you have to have this median landscaping?
Which part of the?
No, but from where to where?
This is the total is approximately 9 point.
It is 4.35
kilometer.
So, Mr. Ward, where does it begin and where does it end?
From Priyadarshini Park to Worli.
No, from Priyadarshini Park, it's underground. So there's
Priyadarshini Park is underground.
It's underground. And it comes out at Worli.
From Priyadarshini Park.
It goes underground at Marine Drive, Netaji Subhash Chandra Bose Marg, and then it comes out at Worli. So where do you want to do this? Where do you want to do this actually?
My instructions were from Priyadarshini Park to Worli, but I will find out.
But whatever
That's why they want to give 30-year contract.
I don't think.
Let us file a reply there.
The underground. Only a minute. Only a minute. Everyone travel. You also travel. I also travel sometimes. But so far as the tunnel is concerned, I don't think there is a space for.
No, there's no space for a media in the tunnel. So where is this going to be actually? That just
whatever is outside, possibly, but it's
So where exactly? Ask, is there any officer traveling today to Delhi? A BMC officer is here?
No, it is not there, but we just find out.
All right. Ask one of your juniors to find out. I just want to know where you are making this.
Numbers,
It's about 9 kilometers.
We have anyway, your lordship may.
All right. One more question I wanted to ask the solicitor, because initially you said you wanted to give a 30-year contract on a first come first serve basis.
Yes.
Now, yesterday you said that there's some change of policy here.
Yes. Well, they were objecting. Our idea was not to earn anything out of it. Someone, without any commercial benefit, someone will maintain it out of love for the city. And Tatas were ready, agreeable.
Tatas are ready.
Tatas are agreeable.
What is the extent of the advertising that will take place by the way?
They will have a small logo, not.
Are there going to be hoardings that you have?
No, small logo, there is a size also prescribed.
Because, you know,
1 feet by 2 feet.
We don't want hoardings in the middle of the road.
1 feet by 2 feet. 1 feet by 2 feet. Logo.
And at what distance separated have you entered into a draft agreement? Is
30 meters, my lord. Between the two, my lord, 30
But
meters.
I just want to point out something before your lordships go.
Mr.
This
Singh,
is directly contrary to your lordship's order of 30th September.
Mr. Singh will hear you, don't
But, my lord.
We're just trying to also understand what this whole application is.
My lord, yesterday I spoke to the commissioner on my learned friend's phone that why are you insisting? Why can't we go for a tendering? He said there is a condition in the order that will not have any commercial use of that that particular area.
So basically, the Tatas are going to beautify the median landscaping free of
and my lord,
what we will do is, Mr. Singh,
central median.
Sorry, Mr. Mehta, subject to hearing Mr. Chandra, what we'll do is this. We are not going to get into how you're going to award the contract, whatever. We will only say that permission is granted to you to carry out landscaping of the road median as sought, because we don't want to, because the moment we say, yeah, we are permitting you to give it to the Tatas, or that they put the logo after every 30 meters, that means we have given our stamp of approval.
I have something more to say. My lord, we have no objection if your lordship, my lord, accepts our request that we will tender it. Whoever gives.
So we don't even say that. So we don't even want to say that. You take a call. Why should we run your municipal corporation? You do what you think is proper under the law. If your decision is flawed, somebody will challenge it before us or before the appropriate court. But we will today, this is an environmental matter.
Correct.
Therefore, we are not now concerned with the award of contracts, etc. over here.
Because
we will only say that we are allowing the request of the municipal corporation for doing the landscaping on the median of the road, because that is also important to ensure, that there is a little bit of division between the oncoming and ongoing traffic, so that, the medium also sort of poses a little bit of a barrier between high-speed vehicles on both sides of the road. So I think that's all that we need to do. Now, what they want to do, let them take a call. If somebody wants to object to come to us.
Just the prayer.
Well, the condition.
Did not have that prayer.
The prayer is expressly to allow them to do it as per the guideline which they have now framed
Mr.
on
Singh,
11th of October.
Your point is valid.
And I'll tell you what
Mr. Singh, your point is absolutely valid. We are not going to give our imprimatur on a particular commercial arrangement.
No, and your lordships have restrained the commercial arrangement. Please see your order in this matter.
Mr. Singh, but then why do we have?
No, sir. Therefore, I just want to.
We will only permit them to carry out the landscaping of the median.
So I need to say something on that, Lord. Your Lordships on 30th September 2022, in the order categorically said that there will be no commercial use whatsoever. Now what they're doing is they are allowing, they want to allow private sector to do this. This is in the teeth of section 61 of the mandatory. No, just a moment. Your Lordship will
commercial use.
Mr. Singh, you have also lived in Mumbai.
No, I'm
you
not.
know the difference when a good company does it and when the BMC gets one of its tickets.
Not BMC
This
garden
is not
department
commercial
is one of the
use,
best
but
departments.
Tata's,
Your
this
Lordship
is
will
not a
know.
commercial use.
BMC's garden department is one of the most efficient
That's
departments.
okay to maintain the hanging gardens, but not to maintain 9 kilometers of a road.
No,
they don't have that kind of man.
Just give me a moment.
Where will they get that?
I'm trying to persuade Mr. Singh. Mr. Singh,
just allow.
Only a minute, Mr. Singh. I'm just trying to persuade him. Lord, for Tatas to put a plate of 2 feet by 1 feet is not a commercial purpose. He's doing it for 9 kilometers or whatever, 5 kilometers. This can't be said to be commercial use of the lake.
Their guideline to give it to private sector is based only on
4.5
promotion of the person who does it. Your Lordship may just, my Lord the Chief will recall, Lord, your Lordship recall in Anahita Pandol, when I was on the side where the learned solicitor is in Bombay, I was for the BMC. Your Lordships actually took us to task, and rightly so, because on the signage, road signage, we were allowing signs on the commercial signs on the sides, all the signage throughout Bombay to give directions, etc. over the roads. And we were severely taken to task, saying this is a mandatory duty under section 61. The corporation has to do it itself. They cannot allow any commercial exploitation. Now, in this case, on 30th September 2022, in this case, your Lordship allowed them to carry out this this extension of the road on the express footing, and your Lordship said the land reclaimed should not be utilized for any residential or commercial development stroke purposes. So for no commercial purposes. So what they are allowing,
just 1 second.
Yes.
What is the purpose of that direction? The purpose of the direction is you have reclaimed sea land. Once you have reclaimed land from the sea, which affects the environment, don't suddenly put up a mall. Don't put up a shopping complex.
Or for any commercial purpose.
But I mean, you are right.
But see the guideline here.
We can't take it to an absurd extent. If they want to beautify the median of the road by planting trees or planting some shrubs.
Section 61 are the mandatory duties of the corporation under Section 61 of the MMC Act. Now, this is one of the mandatory duties of the corporation.
Yes.
They can't.
But mandatory duties doesn't mean that they can't get it done by someone else.
The corporation has
always
to fulfill that. That was the basis on which the Lordships have
mandatory
delivered.
duty does not mean, suppose mandatory duty is to run a public health facility.
Yes.
They can always engage private doctors to give vaccinations.
Yes, but
they have to take the responsibility for it. That's all. So, but they can always get agencies to perform it. In that sense,
please see for a moment if that is permissible. But in this case, because there's a judgment of the Bombay High Court, which your Lordships have stayed only temporarily for the purpose because the matter could not be heard. So your Lordships have ad hoc allowed certain sort of interim arrangement.
30th September 22.
30th September 22, your Lordships categorically said for no commercial purposes.
The Municipal Corporation of Greater Mumbai has moved a miscellaneous application, an interim application, seeking the permission of the court to carry out median landscaping work on the coastal road, spreading over a length of
4.35
of 4.35
is what my instructions are.
Kilometers.
Yes.
4.35 kilometers. Full stop. Full stop. We have heard the Learned Solicitor General appearing with Mr. Maninder Singh, Mr. Ward, Learned Counsel, Senior Counsel and Learned Counsel in support of the application. Full stop. The Solicitor General has submitted that the corporation intends to carry out the work of landscaping after the completion of the coast, since the coastal road has been substantially completed. Full stop. It has been submitted that the corporation intends to award it has been submitted that the agency which is proposed to be engaged by the corporation has agreed to carry out the work of beautification.
They've not yet given it. They've just framed the
Proposed,
guideline.
I said. Proposed. His submission.
Yeah, they are not submitting that it's already
proposes to engage, has agreed to will carry out the work free of charge and without any revenue implications for the corporation. However, it has been submitted that the corporation may consider allowing the agency to put a logo of small dimensions, not in the nature of a hoarding in or around the coastal road, so as to not in the nature of a hoarding in or around the coastal road. Next, Mr. Siu Singh, Learned Senior Counsel appearing on behalf of the original petitioner before the High Court, on the other hand, submits that by the interim order of this court dated 30 September 2022, a specific embargo was imposed on the municipal corporation on carrying out any commercial use of the reclaimed area. Full stop. Prima facie, we do not find that there is
I just want to point out.
Just one second. Moreover, it has been submitted that it is one of the mandatory duties of the municipal landscaping and beautification is one of the mandatory duties of the municipal corporation under Section 61.
Under Section 61,
subclause
A, B, and certain other provisions.
Section 61 of the Mumbai Municipal Corporation Act 1888. Next, the object and purpose.
And look, just one more submission.
The direction which was imposed, the restraint which was imposed in the order of this court dated 30 September 2022 must be construed in a reasonable manner. Full stop. The corporation, the state having reclaimed land from the sea for the purpose of constructing the coastal road, this court by its interim order was passed in order to ensure that the reclaimed land is not put to commercial use. Full stop. Commercial use
or for any commercial purposes.
Commercial use or purposes.
These companies will want to put up
commercial use or purposes.
That is the commercial purpose. They have to pay huge amounts otherwise.
Commercial use or purposes. Full stop. In our view, bearing in mind that the public interest litigation principally dealt with an environmental issue, there can be no objection to the corporation, to the municipal corporation, being permitted to carry out the landscaping of the median of the coastal road over a length of 4.35 kilometers approximately, as stated during the course of the submissions. Full stop. We accordingly permit the municipal corporation to do so with a clarification that such work of beautification, even if carried out through an appropriate agency, will not be construed to amount to a variation of the order dated. To carry out, to do so by doing the work of landscaping of the median, either through its own officers, through its own staff, or by appointing a suitable agency. So, however, we are not making any observation in this regard, in regard to the proposed arrangement, in the absence of any specific details before this court.
Just one thing. They have specifically asked
corporations.
They have specifically asked your lordship for permission under what they did was
11th October.
This guideline.
We have not said that.
That's right.
But not said that.
Please record my submission, because what they did in 11th October, only for the coastal road they made it 30 years. Everywhere else is 3 years. Throughout Bombay it's 3 years. For coastal road they make it 15 years.
We have not referred to 11th October at all. We are not granting them permission in terms of 11th October. We have just permitted them.
Clear, because ultimately the problem here is they create third-party rights and enter into a contract for 30 years. And here their petition is pending here. There's a judgment of the Bombay High Court today in my favor. Look at how cynical it is. 26 September they come
drive on the coastal road. You will make sure that you have a beautiful median to look at when you are driving down.
The original coastal road was on stilts. It was supposed to be all the way on stilts till Valkeshwar.
Imagine the amount of time we are spending on whether they should put grass and shrubs in the middle of the road. I mean,
the point is only of creation of third-party rights in a petition where they have an temporary
third-party rights.
order in their favor.
rights at all.
There is no, you enter into a 30-year contract, of course it creates third party rights.
You can always tell them to remove it.
Because all the earlier orders your lordships have said are subject to further orders in this. So that also can be made clear.
Always tell them to remove it.
Your lordship may make it clear because you have said so earlier and they have undertaken that it will be subject to further orders of the court. No? Yeah. That may be made clear.
Thank you.
Obliged.
12.
With well appearing of petition assuming led by Mr. Datta, so on his legs in another court.
You at least start. No?
So convenience compilation has been filed. So that is,
but just you start, then you can join in. You start.
And just give me time. Because
no, just start. You start. Come. Otherwise, we'll be dismissing it in default. Huh? You start.
My lords, we just have the convenience compilation.
Yes. What is the point?
Well, the point involved
is whether tax should be deducted at source from the salaries received by nuns, sisters, and fathers.
Yes.
For services of the teachers in the parish establishment.
Yes.
So the salary is paid to the nuns, right?
No, my lords, what happens is that there are circulars since 1940. In fact, I'll show my lords the circulars because the question involved is
the salary is paid. It's paid in the name of one of the fathers, nuns, or sisters.
That was happening, my lords.
They contribute this salary to the parish.
Yes, no, my lord, what happens is...
It's like my saying that, well, I get the salary from the government of India, but I'll retain only 1 rupee, I'll give the rest to a relief fund. Salary is clocked in my name.
No, I'll just clarify that, my lord. Right. My lord, what happens is that prior to 2015, prior to the Aadhaar Act having come, they never had a bank account. So it used to go directly to the institution. So because they take a triple vow of poverty, chastity and obedience, in fact, I'll show my lords. So therefore, there are circulars since 1940.
But why is the salary paid then? So they should be working free of charge.
Yes. So, my lord, the question involved is whether it is application of income or diversion of income by overriding title. So, my lord, there are circulars since 1940. In fact, which we filed. We filed the convenience compilation.
It's a salary which is paid to one of the nuns or the fathers. They don't take it in their own coffers. That's all, because they say we have taken a vow of chastity or a vow of what do you call it?
Poverty.
Vow of poverty.
Yes.
So they won't retain the salary. So the organization bills the salary to the father or the nun, but pays it to either one of the sister organizations or whatever for charitable purposes. But TDS has to be deducted.
No, that's what the single judge has in fact ruled in our favor. The single judge of the Madras High Court.
Yes.
So if my lords may just, I'll get the complete bundle, my lords, because the bundle is outside. The single judge of the Madras High Court has ruled in our favor.
The division bench dismissed the writ appeal.
Yes. No, the division bench allowed the writ appeal. The
allowed the
writ appeal. And so, my lord, what happened was that there was one batch from Madras. The single judge ruled in our favor. The union came up in appeal. In Madurai also there was a batch. There in the single judge, they gave an undertaking that they have no right to this. So based on the undertaking, the writ petitions were disposed of in the Madurai batch. Then the union filed an appeal before the division bench in the Madras High Court, and then pursuant to the impugned order, they also then challenged the Madurai consent order, which according to us, based on which the...
How will this affect the taxability of the receipt of the salary? It will not affect the taxability of the receipt of the salary. Salary is received, but because of the vow of poverty, they say I will not retain the salary because I can't have any anybody in the parish or the diocese can't have any personal salary or any personal income.
Yes.
Otherwise, don't give that salary. If you don't give that salary and work free of charge, that's all right.
So that's why, my lord, what happened is in the Madurai proceedings, in fact, my lord, will just permit me, right from 1940 onwards, Datta is just joining. The convenience compilation, we filed the written submissions. In the Madurai, they gave an affidavit. Based on that undertaking, the writ petitions were disposed of. That they have no claim to that.
They can always change their perspective ultimately. It's a question of taxability.
So, my lord, may just permit me, my lord, I mean, let me...
Somebody, there may be a priest, say a Hindu priest, who says that, well, I will not retain the salary. I will give this money which I receive, for doing puja to an organization. But if the person is employed and he gets the salary, tax has to be deducted if the law is common for everybody.
So, my lord,
how can you say that it's not subject to TDS?
So, in fact, my lord, there are judgments of the Kerala High Court, even under Motor Vehicles Act.
Yes.
Say one of them passes away. When the family makes a claim, they don't get it because of the vow that they take. We filed those judgments, my lord.
Because they have, that is right, because they have, by taking the vow,
yes,
they have completely, they are, in that sense, they are liberated from the mortal bonds with the family.
Yes.
They become completely ascetics. They become ascetics. That's a very different thing. So if an ascetic dies, the family can't claim compensation on account of the death of the ascetic. Because anyway, that person was not contributing to the family. The Motor Vehicles Act stands on a different footing. But in a situation like this, when an organization pays a salary that is treated as salary in the books of account of the organization, but that is not ultimately retained by this person, but paid over somewhere else, the application of the money ultimately either to organization A, B, or C has nothing to do with the liability to pay TDS. My brother is an expert.
Keep one thing in mind. These salaries are paid by the government to the aided institution.
Yes.
Therefore, it is a salary in its true sense. Now, what were you doing for all this period of years?
So
how was the amount being adjusted?
Yes, my notes may look at the circulars
Till
1940.
Till the point of time you preferred the writ petition, what was the arrangement?
My lord, the arrangement was in 2015. Someone writes a letter to the income tax department because we are protected from circulars right from 1940. 1940, 1944, 1977 CBDT.
Tell us one more thing. Do they file income tax returns?
No.
Mr. Datta, sir.
Okay.
Sorry, let him continue.
The government pays the salary. Yes. It must be going in the account of that particular teacher or what, whoever.
No, it doesn't go.
What is your arrangement, Mr. Datar? What is the arrangement with
Yes,
the government?
I'm so sorry, I never expected you to reach a very apologies. Yes, what happened was, these are people, one second. Can Lordship hear me, Milord?
Yes.
These are people who have taken the triple vows. They have renounced the world. They don't have salary. They don't have bank account. They don't have credit card. They have nothing. They work from the church. To answer Justice Pardiwala's question, from 1940, there is a circular that whatever money...
Where are they working? Where are they working?
Missionaries.
They work in Jesuit schools. They get transferred from place to place.
They work in different schools.
Yes, yes. I'll tell you what happens. Suppose there is a school. Let's call it St. John's School. Now, that school will have 20 teachers, of which 10 teachers may be Jesuit priests who have taken the triple vow.
Now is St. John's School an aided school? In your example, is it an aided school?
Yeah, aided school. There are aided schools. So there are teachers who are not...
From whom? The grant comes from the government.
The grant comes from the government. Earlier, the listing was the grant was going straight to the diocese.
Grant we just paid to the... It is a salary grant.
No. The same grant is paid to the bishop and... No. The diocese is taxed.
The diocese is the number of teachers and give you a salary grant.
No. It's not a salary grant. It is not a salary grant. Lord, can I come to court and argue, my lord? Because I'm only...
No, Mr. Datar, it's not a capital grant. It's a salary grant.
No. What happens? The system done because we don't pay provident fund.
These Jesuit priests are teachers in the aided schools.
No, they could be in their own Christian schools also where government gives a grant.
Fair enough.
Mr. Datar,
yes.
Just give us some idea.
Yes.
At the end of the month,
yes.
Say there is X, Y, and Z, 3 employees.
Yes.
They are working with the missionaries.
Yes.
They have taken a vow of poverty.
Yes.
At the end of the month, the salaries of X, Y, and Z will go where?
They will go to the diocese, and the diocese is registered as a charitable trust, and the diocese pays tax if they don't satisfy the thing. It goes to the diocese.
Diocese.
Yes. And the diocese is taxed as a charitable trust.
From the government to the institution.
It goes straight to the diocese.
The institution will transfer this to the diocese at the end of the month.
So it is...
No. Sorry, Lord. Earlier, what used to happen was
the government pay the diocese? Government will never pay the diocese.
No, that was the practice. Government,
the practice. Will pay to the school.
No. The point was, though technically it will pay, but the fund used to go straight to the diocese.
Government, it's not technically. Government says that, well, this is our budget of, say, 5,000 crores for aided schools. So they will say to this particular school 25 lakhs.
Yes.
This is your aid. This is the grant in aid.
Yes.
School will then say that, look, we will not distribute it to the teachers, but we will give it to the diocese.
Yes.
In the hands of the school, once it comes, it's clocked as a salary for these teachers.
No, it is not. It is not.
They don't take it because they are paid for, they take the vow of poverty.
No. Well, what happens? It never comes to the account of the school. It never comes to the school. I can explain the accounts. What happens is
government will never pay a diocese. They can't contribute to a religion.
I can bring the accounts and show
you. They give the money as a salary grant to the school.
No, they don't. They don't. Great respect. No. What is to happen was because of the board circulars, because these priests don't pay provident fund, they don't pay any kind of thing. The money goes to the diocese. The diocese is registered as a charitable trust under Section 11 of the Act.
They have to disburse 75% of whatever money they collect for charitable purposes. The priest gets nothing. For last 85 years, the priests were never taxed.
Anyway, even if it is you pay TDS, you
Yes.
can always make a claim for refund.
No, I am not an SSC at all. I'm not an SSC.
Claim for
I
claim
don't
a
claim
refund.
return.
Claim a
No,
refund.
No, I'm not an SSC. But the larger question is, suppose your lordship takes salary, I get a rent-free accommodation, are you going to tax me on perquisites? I get free food, are you going to tax me on perquisite? But I'm not a salary because under Article 25...
It will be taxed unless there is a statutory exemption. We
No.
get a statutory exemption as judges.
No, my lord, my submission is...
Otherwise, even our petrol and our car will be taxed.
No, my lord.
Equivalent of 200 liters of petrol every month. The government will monetize it and tax us.
My lord, I'm raising an argument of the definition of individual. No, my lord, my definition of individual under the Income Tax Act will only include a person who's capable of receiving money. Now, my lord, suppose the priest dies in an accident. The monetary compensation goes to the diocese. There are judgments of the Kerala High Court and Madras High Court saying...
There's a reason for it. Because once you enter an ascetic order, you have completely, that person has completely cut off all bonds with the natural family.
Yes, he can't earn money also.
When the person dies, that family will have no claim for compensation because that person is at the point of renouncing the family.
Unfortunately, it has come at the last day.
They cut off all their bonds with the family and they join the order, whether it's a Jain order, like a person who joins the Jain ascetic order. Once they have become, monks, once they have become...
No, my lord, may I say this one thing, my lord? Rightly or wrongly, the Central Board of Direct Taxes said, I will not be taxed at salary. That circular has not been withdrawn. That circular still holds the field. Your lordship's own judgment in the excise case says they can't act contrary to the circular. Number one. The single judge held in my favor the division bench against me. Justice Muralidhar is appearing for the remaining 2,000 odd priests. I am appearing for 2,500 priests. Can lordship hear me, my lord? Can lordship hear me?
Yes.
Can lordship hear me, my lord?
Yes, Mr. Datta.
Yes. My lord, the point, I'll put my point stepwise. First is, I'm covered by the board circulars from 1940, 1944 onwards. These priests are not liable to income tax, they're not liable to PF, they're not liable to anything. They are virtually like a civil debt, they are just people. Now, my lord, I was going to argue the definition of person in the Income Tax Act includes an individual. An individual can be taxed. Now, individuals can be of different types. Suppose I've taken the triple vows. I am not capable of earning taxable income because the judgment Justice R.K. Agarwal says, it's a very nicely, he puts it this way. He says, not every receipt is taxable. It should be a receipt of money. If that receipt is taxable, then it becomes income. What we understand as income in the Income Tax Act is not a receipt of money. It is a receipt of money which is taxable, which becomes income. Now, priests don't get...
Thank you, Mr.
No, please, my lord, please don't. Please, my lord, 4,000 priests are affected, my lord. Is that...
13. 1313. What is Godavarman now? What in Godavarman do we have?
No, this is that context.
The Ridge, Delhi Ridge.
Delhi, my lord, to your lordship, that sought for affidavits, my lord, those affidavits.
That one clarification we wanted. We wanted that one clarification of...
Not because in the with greatest of respect, 1 second, my lord, that will permit. With greatest of respect, my lord, on that day in para 20, 2 dates were there. One date was about his knowledge, the Honorable LG's knowledge.
Now tell us one thing, Mr. Maninder Singh, we want to know, going forward, what are we doing to restore the Ridge? Tell us that. I think that's also very important. What are we doing to restore the Ridge?
For that plot, we have sufficiently provided for at least 10 times more trees to be planted. And apart from what is required to be done in this case.
Mr. Vikas Singh, how many trees? Yes, Vikas Singh is appearing for whom, Mr. Maninder Singh?
We are both appearing for DDM in both the matters. In the
DDA.
There are 2 matters.
All right.
Now,
we want to know how many trees were cut and what is being done to restore the Ridge and to carry out reforestation. I mean, what are you planting?
This is in 2 parts. One is the requirement of planting a certain number of trees depending on the number of trees that are felled. So if I fell 1 tree, I'm supposed to plant 10 times or 20 times the number of trees which are felled, which is
felled actually.
As per the forest survey report, which has just come for the Lordship's last order.
1760, my lord.
How much, Mr. Shankanaran?
The number that they have given is 1,136 trees inside RFA and 534 trees outside RFA. Now, those have to be fully restored because that's the calculation that they have. 1,136 trees inside the RFA, which is the forest area, and 534 trees outside the recorded forest area.
Or there is a discrepancy in that.
Totally comes to 1,006.
Anyway, let's.
No, the offending authority can't give you the numbers. Please, 1 second. I'm the petitioner. The forest survey's report makes it clear that there's a discrepancy.
Mr. Maninder Singh, we now.
So we'll err on the wrong side. Let it be the higher number of for replantation. And we'll go difficulty abiding by whatever number of trees we have to plant.
136 plus 534, how much does it make?
1670.
1670. Now, Mr. Shankanaran, if they have cut 1,670 trees,
yes,
how do we go forward? Because otherwise.
They've already started replanting those 1,670 trees. Perhaps a little less is what they're replanting at the moment.
Right.
The committee is doing it. That job is going on of the restoration. That's been recorded in
committee appointed by your lordship.
Appointed a committee of 3 members, which is headed by
Mr. Pradeep Kishan.
Mr.
Lord, there are 2 aspects, Lord. Today
Yes,
the contempt
experts have been appointed.
Are you referring to that Dehradun committee?
No, my lords. This is only in these proceedings. In these contempt
In this very matter, your lordship
by these orders.
Now, how
or
many
this
trees have been planted as of date?
That somebody else, forest survey will have to give us some details about how many are planted and what status is there of that.
Is there any independent monitoring mechanism to see how many trees have been planted?
Forest survey of India will give
you that committee under the your lordship said you will do everything now under the supervision of the committee appointed.
Now just one second.
Approximately 3,000.
So whatever compensatory forestation we have to do, Lord, we'll do that.
Direct you to plant. Is there any order directing?
No, your lordship's
not yet.
That 16th May order, your lordship's appointed Sri Ishwar Singh, a retired IFS officer, Sri Sunil Limaye, who is a member of the CEC, and Sri Pradeep Kishan, who is the author of all those books, an ecological gardener, to be associated with the work that was assigned to the FSI to find out how many trees had been cut, to inspect the entire area, and to monitor all aspects dealing with the afforestation.
So what Mr. Shankanaran, what we could perhaps do is,
yes,
we will say that the report of the Forest Survey of India, Mr. Maninder Singh will request you, don't now quarrel on the number of trees.
No, we have no issue, Lord. We'll not want to quarrel on that. We will do the compensatory afforestation, Lord, of whatever is.
A 3-member committee appointed by the order of this court dated 16th May
yes,
shall ensure that
compensatory afforestation
that have been planted should be
separate from the restoration. This is all restoration. 1670.
No. This restoration can't happen. Let me be with you, Lord.
No. I'm just explaining something. 1670 would be towards restoration. Your lordship, same order of May, has also
this
said
restoration
we
will
plant
mean that
100 trees for every tree that has been cut as compensatory afforestation separately. That's your lordship. That suitably there is a policy that they have to follow. Unfortunately, I'll tell you.
It will never be functional.
1670 plus 1670, they should plant on the ridge. All right? And
yes. As compensatory.
Trees cut 100 times the number of every one tree cut.
Yes.
In terms of their policy.
Correct.
That will be elsewhere because there may not be that much of space in it.
That will be an addition. Yes.
So I think we can.
That's right. So this road has to come.
It's not necessarily prejudicial. Preparatory measures are required about how these authorities function. Which is why we had sent 2 emails asking, because your lordship's order permitted us to inspect the files. We needed to inspect the files, but we were told that we'll have to ask you in court once again. That's what the order says. Order says that. So I gave them instruction to send 2 emails to your lordship's registry. We sent one on first.
Our order says that we can.
Exactly. But we kept asking them and they were told we should ask you.
But tell us what now, reparation measures, what else to be remain?
No, there will be something with reference to how these clearances have been going on and permissions have been granted, because this is, no, if he wants to.
So let the road be constructed.
Then allow me to make a submission.
Can we do this?
Let the compensatory or forestation be done. Let the road be constructed.
What further directions are to be passed, we'll make them as a part of our order now. We have got now committee plus 1670 plus, just as Brother Pardiwala said, plus 1670 plus 100 trees to be planted for every one tree to be which has been cut.
Yes.
We will introduce a monitoring mechanism to ensure that the trees are surviving.
Correct.
Just give us some idea tomorrow on what kind of monitoring mechanism we ensure to
that's
place.
on this.
The committee can itself supervise whether
it's absolutely on this,
Very
but this is
And also the
emblematic
road
of a larger issue with reference to how these kind of things constantly happen. Your Lordship recall there were 2 contempt petitions before your Lordship.
Can you then give us
mechanism to protect the trees will be integral to this.
You can offer your comments.
Yes.
You can tell us what kind of enforcement mechanism we can put into place to obviate this in the future.
Yes.
We'll like we did in the road widening cases, the UP road widening case, where we said you can't have these bulldozers coming in. We have now laid down guidelines.
Yes.
You tell us tomorrow what kind of just 5 or 6 safeguards we should put. We will adopt them as our safeguards and issue directions for the future in that.
That's right. And also,
if you're permitted to inspect the file today, I'll try and give you that submission at the earliest.
Just a page, right? Not
just a page.
But would you file it? You have no objection. You already passed that order for inspection.
They can inspect it.
I do believe at some point the sharp end of the wedge is required for people who deal with these issues with impunity. If the court doesn't set an example, this is all being done at our expense, the public's expense, all replanting.
We want to give edge to our order because we'll be justified even in the contempt jurisdiction.
Yes.
Because we have found a breach.
Yes.
Now you tell us, therefore, tomorrow, formulate it for us.
I'm listing the breaches and I'll show you.
No, don't list the breaches as much, or you list in just a para what according to you are the breaches, but more importantly, what is the sort of mechanism we should put into place to obviate this in the future?
We'll do that.
But then, we can move forward then.
And
And likewise, tomorrow, you give us on a page what is the extent of the plantation which has happened.
We will give it.
Both within.
We'll give all the detail tomorrow.
Tomorrow, a page each.
File inspection.
If your Lordships may give me a minute, my lord. I was the amicus, my lord.
My associates, my lord.
There's a distinction between restoration, my lord, and compensatory afforestation. My lord, restoration is you have to restore the area as such.
By DDA.
No, the road has to come, the hospital has to function, the hospital is awaiting inauguration, not for the paramilitary forces. So ultimately, your Lordship will have to balance equities.
There's no balancing when you committed contempt. I'm sorry.
There's no question of balancing.
Contempt, where's balancing?
You misled this point.
The hospital is being built for paramilitary forces.
We are not going to give any direction, any release to them.
Yes.
We will only put safeguards now to obviate this in future. If they want to do something,
that's right. And
to the court.
Absolutely.
The warning clearly has to go. No, but there can't be a fresh option. Now we are doing restoration. And
No, that road has to come. There is no question of that road.
We'll do that. All right, we got that.
I'm good.
Item 16 on your Lordship's board is that other backward commission matter, the West Bengal matter, where we can't give reservation to people because the other backward.
I wish I had some more time, but
no, correct. So can it be early next week, pending for.
Lordship, hear me, my lord.
Yes,
next
week itself.
Item.
Can your Lordship hear me, my lord?
Sorry.
Can we have it on
12,
Tuesday?
my lord.
Well, had one additional.
Can we have it on Tuesday?
Yes,
Tuesday.
My lord, item 12, Lordship can hear me, my lord. Item 12. The Lordship can hear me on item 12, my lord.